All right, good afternoon, everyone. We are live on the YouTube stream and through the DLS website. Today, we have 10 bills on the docket. So this is our second bill hearing. So welcome, everyone. I'm going to just quickly go over the order, but Senator Lee, you are first. But before you start, I'm going to go over the order so that folks have it at home. So first, we'll start off with Senate Bill 250, which is Senator Lee and Senator Wallstreicher. We'll then move to Senate Bill 28, which is Senator Patterson. Senate Bill 74 will be third. Senate Bill 122 will be fourth. Senate Bill 159 will be fifth. Senate Bill 91 will be sixth. Seventh will be Senate Bill 143. Eighth will be Senate Bill 220. Ninth is Senate Bill 190. And 10th will be Senate Bill 101, which is Senator Kagan and Riley. So with that, Senator Lee, I'll go ahead and unmute you here, and the floor is yours.
Can everybody hear me?
You can.
Chairman Smith. Thank you, Chairman Smith, and Vice Chair Wallstreicher and Vice Chair Wallstreicher for sponsoring this bill as well. Maryland's law to protect spousal rapists originated around the time we were founded as a colony, as you know, almost 400 years ago. The notion, of course, originates from the belief that a wife is a chattel or property of the husband, as the idea of wife as property and the defense to sexual assault due to marriage is antiquated, offensive as a concept, and therefore repeal requires no half measures or qualifications. This is a repeal of the spousal defense. Today, unwed victims of sexual crimes have more protections than those who are married to their assailant. This creates inequities simply because of the marital relationship. Current law does provide marriage between the parties provides a complete defense to the allegation of sexual assault when the victim is unable to consent. Under the current spousal defense, spouses cannot be prosecuted for rape in the first degree, second degree, sexual offense in the third degree, or sexual offense in the fourth degree, with certain exceptions where there was where they had lived without interruption apart under a written agreement, or at least 3 months after the rape. And also if there has been a decree of limited divorce, but still this defense still stands. The defense could be as frequently used in incidences of the spouse being unconscious or drugged. And so can you just imagine the horror of finding you've been sexually assaulted while clearly unable to consent, and that the perpetrator of this crime, the person who should be someone that you're able to trust completely, cannot be punished because you exchange vows. Our idea of marriage is an esteemed institution which we must protect. It's greatly weakened as a result of this amputated spousal defense. A full repeal of this defense and criminalizing rape and sexual crimes without marriage being a loophole sends a strong message to victims and perpetrators that the law will provide the highest level of support for victims. This legislation helps place Maryland's policy in this space from the 17th century and finally in line with other 33 states who have eliminated the complete defense to spousal sex crimes when the victim's unable to consent. For these reasons, I respectfully request my colleagues to vote favorably on SB 250. And I'd like to also mention that the Women's Law Center was not able to file their written testimony because of some computer technical glitch. But the groups that in addition to Michelle Smith, Lisa Jordan, Carrie Williams, and our wonderful state's attorney, Aisha Brayboy, other supporters include the House of Ruth, of course, the Maryland State Bar Association, represented by Michelle, and the Maryland Coalition Against Sexual Assault, represented by Lisa Jordan, the Maryland AG's office, represented by our wonderful Carrie Williams, and Scott Schellenberger of the Baltimore County State's Attorney, Townsend University Department of Psychology, Dr. Christina Darris, Secular Maryland, the Commission for Women, Montgomery County Women's Democratic Club, Turnaround, and others who may have submitted written testimony. So I respectfully wish that you all will look at the written testimonies submitted, as well as considering those who are testifying today. And I'll turn it, Mr. Chairman, I'll turn it over to our witnesses now.
Thank you, Senator Lee. And so if there's additional testimony, we'll have an opportunity to submit that. I see two questions of the sponsor first. So as you know, what we do is the sponsor will get questions and then we can do witness testimony. So I saw Senator Huff and then Castley. Is that right? Did I see you with your hand up? So Senator Huff, go ahead. The floor is yours.
Yeah, thank you very much. So the question with this is where we were last year on this. I think there's obviously, I'll start off with saying there's I think we all agree there's a broad agreement that, of course, this was heinous that they ever allowed rape to be excused and marriage being excused, awful law. And I'm not sure exactly when that was first and second degree were repealed. It was before I was in the General Assembly, but third degree last year, and I don't know if there's somebody here, but last year there was somebody who gave compelling testimony on that. The question lies on this, on fourth degree, and that my understanding of fourth degree, and if somebody can explain different to me, that fourth degree is essentially touching of somebody's intimate area. And even from the AG's letter, consent on it is, it's unclear how you would figure out consent on it. So I guess the simple question is this, where we were on last year. If you have an example of a wife who comes up and grabs a husband's buttocks, would that not fall under this now as a crime?
Senator Lee, you're still muted, but I just asked to unmute you, but go ahead.
Okay. No, I don't think that would fall under fourth degree, because that's what they consider, that type of touching is kind of like a common expression of familial or friendly affection. And I don't think I think you'd have to look at the facts, that's all. And I think the AG's office can explain that more about your question about consent, and because I'm not going to talk for the AG.
Well, yeah, the AG's letter was very unclear. That was up to a court to decide.
Well, that's why Carrie Williams is here to answer your question.
So when we did the fourth degree statute was created so that we would have a statute for trying to figure out behavior. I mean, this is a newly created statute, fourth degree. And we created it so that if you had a creepo on the metro go up and grab a woman's breast, for example, you didn't want to just have it down as an assault. We wanted to have them down as a sex offender. We don't have it listed. Or we also did it for positions of power. But when we start to get into married couples who are often intimately touching each other, aren't you worried about that this has a statute of limitations, I believe, for 1 year, that if you had a case of divorces, where they get really ugly and everyone starts charging, or you had legitimate abuse, let's say a husband strikes a wife, the wife charges it, and the husband can come back and say, well, the wife intimately touched me within the last year, so I'm going to charge her with a fourth degree sex offense.
I don't see a scenario like that. I don't see that in the real world. I mean, you have to look at the facts, Senator, and I don't think that would happen.
Do you have examples of where do you have anyone examples of this? Because my understanding is fourth degree is rarely charged in general. Do you have examples of this?
Sure. Yeah. For instance, there's an example where a man violently shoves his hand down a woman's pants and into her underwear area and then gropes her. And an example where they were in a public place.
This was a husband did this to a wife? Yeah,
the husband, yes.
Was he charged with assault?
He was charged, this would be a fourth degree sexual offense.
Although, was he charged correspondingly with assault? Because assault in the state of Maryland, just to be clear, Maryland's the toughest state in the country when it comes to assault. If they charge him with a simple assault, it would carry a 10-year penalty.
Yes, I know, and fourth degree is only a 1 year. I think that probably Lisa Jordan can give you some specific examples of fourth degree, and I'll defer to her to do that.
Well, just the last thing. So I mean, to me, fourth degree, we always created the example that we use, especially when I was in the House when we were debating this, was that if somebody, you wanted to create something that if somebody walked up on a beach, a stranger, and grabbed a woman in the, say, the bikini area, this is what we used to use, or it could fall the other way, it's both sides, that you would have
Why
a
should being
charge.
married get you off? Why should the institution of
Oh,
marriage?
I'm not done with my question. So
That's the fourth degree. I don't think-
here's my question. So that if somebody grabs someone inappropriately, we wanted to be able to charge that person as a sex offense. So it was known that they had done something that was a sex offense. So if being married doesn't, is the idea that being married doesn't, that there's not a, that there's not an implied consent to familiar touching? I mean, because what would be, if somebody walks up on the street and grabs someone or touches someone in an intimate area, that's a fourth degree sex offense. But clearly husbands and wives do that all the time. So if you did this,
what if the guy did it and they were married and she didn't consent to it and he knew it and she knew it? Why should he get off just because they're married?
so in your bill, how would a husband or wife gain consent from the other partner? Would it be verbal before they touch?
Well, I think you would have to look at the facts. You would have to see, what they've done in the past, what they've done in the future. I think consent is consent and non-consent is non-consent. I think married couples pretty much know.
So, well, no, they don't, because we're talking about the law and we're talking about
Well,
creating a new crime. So my question is, you would have to receive.
I think
you'd have to receive-
a husband and a wife certainly know each other when they're married, okay? And if it comes to a situation where the wife does not want to be touched in a sexual way, I think that you as a husband would know that.
Well, we don't, you'd have to get into, so this kind of offense is not a mens rea charge in that if you walk up on a metro and you grab somebody in an intimate area, that's a fourth degree. There's no ignorance of.
There has to be no consent in intentional touching, genital, anal, or other intimate area for sexual arousal or gratification, or for the abuse of either party, with no consent.
With no consent. So you would have to have verbal consent for basically intimate touching of a husband and wife if we were to pass this as is.
Well, no, I don't think you always have to have verbal consent, but I think you would know it. You would know it implicitly. And I think that, the Carrie Williams can give you more specificity with respect.
Well, I was just curious, how do we say to it? Because the line is clear for the public. If you're out in the public and a stranger walks up and grabs you, that's where we created this law. There's no
what if it's a husband?
There's no argument.
Comes up on a beach and grabs you too. You mean he's off scot-free and there was no consent?
Well, no, I'm trying to figure out though, because there's obviously a different relationship between a husband and a wife and then a stranger's on the street. With a stranger on the street, when they touch you inappropriately, it's automatically a fourth. There's no mens rea. There's no consent required whatsoever. And what you've just said is that you would have to just know, like mentally. There wouldn't have to be anything said. You would just have to mentally know. I don't know how I don't think we should pass laws expecting people to be mind readers. We have to explain this in the law.
Fourth degree sex offense does have to involve an element of consent.
It has to involve. So you
can't just go and get,
I'm gonna chime in here now. We're going into a little bit of a feedback loop. So
okay. Well, can we let them?
I don't know. I'd like to have somebody explain to me where it provides consent, because you don't right now. If a stranger comes up on the street and grabs you intimately, there's no consent. We don't ask for that. There's zero mens rea required in my understanding for this. That if you walk up and grab somebody, that's why we created it.
All right. Thank you, Senator Huff. We'll now move on to Senator Casserly.
Good morning, Senator Lee, and thank you for addressing these issues. I guess this is a preliminary. I would not in any way support any piece of a law that would allow rape for people married or unmarried. There would be no excuse. But so I am my concern though is that in your opening you referred to this as protecting marital rape, and that you suggested that marital rape is still, defense of marital rape is still the Maryland law, and that it's time to repeal the ability to engage in marital rape. But when I look at the current law, which is included in Senate Bill 250, and it refers in Section A, it says that for the first one there, 3303, that is rape in the first degree. The rape in the first degree, of course, requires force. But then if you go down to Section B, that's the part that you're saying is the spousal exception. But the spousal exception, if you look on page 2, doesn't look on page 2, lines 5 and 6, it doesn't apply if you're using force. So rape in the first degree requires force. Well, if you have force, then this marital exception doesn't apply. So that knocks out rape in the first degree. Rape in the second degree, that's 3304. That also requires force. Well, if you prove force, you just knocked out the marital offense on page 2 in lines 5 and 6. Because if you use force, you don't have the marital offense. Let's look at Section 3307. That's third degree sex offense. That also requires force. If you show force.
Well, you're talking about all the exceptions to this.
No,
Correct.
You said that you said this exception on page 2, which is included on page 2 of your bill. You said that exception allowed a husband to escape prosecution under 3303, 3304, and 3307, which would be first, second, and third degree rape. But in reality, it does not provide any defense at all to any of those, because in all of those offenses, it would require showing of force. And if there was force used, the marital exception doesn't apply. So there is no marital exception to rape.
I don't think I said that. I really do not think I said that.
Marital rape is an antiquated concept. That was your opening line.
Yeah, that's what I said. Yes.
Yeah, well, that's what you said.
I did not say that about force. I did not.
Yeah. So, but my point is, we're not really here today talking about marital rape, are we? We're here talking about
under the current spousal defense, spouses cannot be prosecuted
for fourth degree sex offense.
Second degree, third degree sexual offense in the fourth, with the exception the spouse can be prosecuted for rape in the first, second, third degree offense if the spouse lived apart without that interruption under written agreement or at least 3 months after the rape, prosecuted first, second degree rape, third degree, fourth degree, if they lived apart without interruption under decree of a limited divorce. And then there's that section about the force. That's what I said.
Right. But
I don't know what you're talking about.
The first two don't apply.
But I think this should I think that there should be a full repeal, really.
Senator Lee, if we could just have just Senator Cassidy get his question out.
Yeah. So the point of my questioning is that we're really here talking only about 3308. That's fourth degree sex offense. First, second, and third degree rape really are off the table, because if you focus on page 2 of the bill, lines 5 and 6, it says if you acted with force, this is no defense. And first, second, and third degree rape require force, so you got no marital defense. So let's focus on fourth degree sex offense, because that's all we're really here about, right? And fourth degree sex offense, as you properly pointed out, Senator Lee, is touching in these intimate areas without permission or without permission. And so it does not require force, and therefore it's without permission. So we're really talking about the crux of this bill is, can a spouse, can a husband or wife touch the intimate areas of the other person's body without saying, can I have permission to touch you? Because if there's already a separation, if you've already told them not to, and they persist, that's force. And so you don't have the exception. So this whole bill is about, can you be prosecuted for reaching over and touching your spouse's intimate area without asking first? Because once they say stop, once they say go away, and you persist, you've done that against their wishes, and you don't have the marital exception, right? So let's focus on this. And so that's what I really just wanted to bring out, focus on us on what we're talking about here. And the issue is, can a spouse lie in bed next to the other spouse and without announcing anything, slide their hand onto an intimate area of their body? Because under your bill, the minute you do that, you have committed a fourth degree sex offense. Now your spouse can choose not to prosecute that, but that would then be a fourth degree sex offense. So every time a spouse, male or female, reaches over and touches an intimate part of the other spouse's body without permission, you just committed a 4th-degree sex offense. So that's what this bill is about, isn't it?
I think it comes down to consent, implicit or explicit. And you just have to look at the facts. Every case it's got to be by case basis. And I think
But isn't
if
the
you're a
marital
married
exception?
couple, and I am, I think you know the difference.
But isn't the whole purpose of the marital exception so that the courts don't have to look at the facts, so that we don't end up in court talking about who said what in the marital bedroom? Isn't that what that's all about? Where the only evidence you got is, did you say yes or no on a 4th-degree sex offense? Because that's all we're going into court on. Literally, these cases would be, no, he didn't hit me. No, there was no force used. We were lying in bed and he reached over and touched my pubic area, or she touched my pubic area, and I want to charge them with a 4th-degree sex offense. And that would be the trial. We would go to court and you'd have husband and wife in there. They were together in the bedroom, and it's just the lack of consent. So that's, just want to put this whole thing in perspective. So with that, maybe these other follow-on witnesses can explain to us why as a public policy, we want to have spouses on a daily basis across this state committing 4th-degree sex offenses unknowingly, because every time they reach over without getting the consent of the other spouse and touch their private areas, that they've now committed a 4th-degree sex offense. So I'm just curious. So maybe some of the witnesses can explain this through. Thank you.
Thank you, Senator Casserly. Senator Bailey is next. So Senator Bailey and Jackson, you're getting a little bit of a sample of what JPR is like. Senator Bailey, here you are.
Good morning. Good morning, Senator Lee. I have a couple questions, and I'm sure my colleague is going to bring these up. But the example you gave, Senator, of a 4th degree is really not a valid example, because clearly in Maryland, that is an assault. An assault can happen between married couples. There is no defense for that. The issue is that we're talking about with 4th degree is, how do we grant or gain consent? And as we all know, spending much time in court, if it's not written down, it didn't happen. And so is verbal consent going to be enough, or do we need written consent? Because as we all know, in responding to many different assault cases, people change their mind. Yes, I said okay, but then no, as things went on, no, I didn't. And when we're talking about a simple touching, because we're just talking about 4th degree, because 1st through 3rd is already covered in what you can be charged, are we going to have a written consent form that is going to be required by the day, by the week, by the month? I just want to know where this is headed. Thank you.
No, I don't think you have to have a written form. That doesn't happen. Okay. And like I mentioned before, if you're in a marital relationship, you know there's no consent or no consent. I'm married. I think it's a sacred institution, but I don't think that being married should give you less protections than if you're a cohabitation situation. And just to be clear, I don't think consent to touching does not have to be explicit, and most definitely doesn't have to be in writing. And I think that would be silly to require to put it in writing to prove consent in these types of cases. It's a result of verbal and nonverbal communication between two people that establishes what they do or do not find acceptable in a relationship. And of course, consent can be withdrawn too, but also it could be not given as well. So that's what I'm saying. I think you just have to evaluate each facts of the case, and certainly not have to put that in writing. And Senator Bailey, I think probably Carrie Williams and Lisa Jordan can give you specific incidences.
Thank you.
All right, thank you, Senator Bailey. Seeing no further questions for the senator, thank you, Senator Lee. We'll now move on to your panel.
Thank you.
So next we'll have I see Ms. Jordan, Lisa Jordan, you are up next. I think we're good.
Thank you, Mr. Chairman. Just took us a second with the technology there. Good morning. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. The Maryland Coalition Against Sexual Assault is the coalition of all of the rape crisis centers across the state of Maryland. We are devoted to ending sexual violence in the state of Maryland, holding offenders accountable, and assuring that survivors have access to accessible services. We urge a favorable report on Senate Bill 250. It is one of our top priorities. This bill passed the House of Delegates last session, supported by men and women, Republicans and Democrats. It is a bill whose time has come. And as Senator Lee has ably said, spousal defense laws are archaic. The fourth degree sex offense was enacted, Senator Huff, just to clarify, in 1976, 3 years prior to your birth. So it has been around for a while. A specific example of fourth degree sex offense where perhaps we should have a clearer public policy. A woman gave birth via C-section after a difficult labor. She had wounds and stitches in her intimate areas. She was newly home from the hospital and she was in pain. She told the child's father that she was in pain and could not be touched. Despite this, he touched her intimate areas, saying that the pregnancy made him wait long enough. Under Maryland's current law, if they are unmarried, that is a fourth degree sex offense. But if they are married, the marriage itself is a complete defense to fourth degree sex offense. And although it is correct that force and threat of force, those rapes are marriage is no longer a defense there. Keep in mind that this issue is before the legislature, again, because of an actual case in Montgomery County involving a husband who drugged his wife unconscious and then raped her. She found out only because the matter was filmed. And because of that, in that situation, marriage was a complete defense. This is wrong. It is past time to change it. But let's move on to fourth degree sex offense. Let's talk exactly about what you're asking about, the common occurrence of stroking a partner's intimate area without explicitly asking first. The heart of this is timing. It's odd for many of us to think about asking immediately before touching your spouse or your unmarried intimate partner. This doesn't happen. It would be bad public policy to criminally or civilly prohibit something that both parties view as consensual. But this is no different than other situations where we consent to some touching in advance. A person might consent to a massage, including touching the buttocks in advance. A person might consent to a medical exam involving touching intimate areas. Even a yoga class might involve an instructor touching a person's hips to adjust alignment. There's nothing about the intimate relationship that deprives them of the ability to consent to future touching. That's what happens between couples. No one's trying to change that. The consent doesn't have to be explicit. It most definitely does not have to be in writing. It's the result of verbal and nonverbal communication between two people that establishes what they do or do not find consensual in their relationship. But consent can also be withdrawn. That is the point of repealing the spousal defense statute. The law currently says that marriage itself is the consent in advance and that it cannot be withdrawn. And that is what is so offensive. This suggestion that marriage deprives anyone of the ability to control when they are touched in an intimate area, and that marriage itself deprives the spouse of the protection of the criminal law simply because they are married. The idea that the courts will look at facts and at people's relationships is not just common sense. Case law supports it, and my colleague Carrie Williams is going to talk more about that. But thinking about the examples that I've provided, just think back to that idea of rolling over in bed and stroking someone, or Senator Huff's coarser examples from last session. If this case ever made it past a commissioner and a prosecutor and went to trial, be confident that the evidence is going to include the past interactions of the couple. And Senate Bill 250 would mean that if those facts included a sexual assault, then the victim would be able to seek redress from the criminal justice system under our sex crimes laws. And that's as it should be. A little bit of sexual assault is never okay, and it should never be okay under the laws of Maryland. MCASA urges a favorable report on Senate Bill 250.
All All right, thank you, Ms. Jordan. We're going to hold questions for the panel until the end. So thank you very much. And we'll now move on to Ms. Williams.
Good morning, Chairperson Smith, Vice Chair Waldstreicher, and members of the committee. Thank you for having me here today. My name is Carrie Williams, and I'm here on behalf of the Office of the Attorney General. The Attorney General respectfully requests this committee to give a favorable report to Senate Bill 250. I want to address specifically Senators Hoff and Casserly and Bailey's concerns about how one would prove that there was consent for a fourth-degree sex offense. I think it's very important to remember that a defendant does not have to prove consent. The state has to prove a lack of consent. And the Court of Special Appeals in 2014 addressed this exact issue in Travis versus State. The court said in that case that to prove a lack of consent, the state can either prove express denial of consent or implicit denial, which is evidenced by resistance or a rational fear of resistance. So those would be the things that were required to exist to prove lack of consent. The court said mere passivity is not enough to establish lack of consent. So in Senator Casserly's hypothetical, where a married couple is lying in bed together and one reaches over and touches the intimate parts of their spouse, that would not be sufficient evidence to prove lack of consent. The Attorney General's opinion letter made it clear that what constitutes evidence of lack of consent is a factual specific inquiry. And that's perhaps why Senator Hoff thought it relatively unclear. We cannot give a cut and dry answer for every circumstance, but we do know that the inquiry into whether there's been lack of consent is fact specific, and the prior relationship between the parties and whether there has been prior consent given and whether that consent might be continuous or ongoing and wasn't explicitly withdrawn is going to be relevant. And it is going to be much more difficult for the state to prove a fourth degree sex offense against a person who is in a long-term relationship or married to the victim than the hypothetical of the stranger on the beach where someone comes up and grabs another person's genitals without saying anything. I also want to address Senator Casserly's suggestion that we are only talking here about fourth degree sex offense. That's not true. The spousal defense also applies to two modalities, both of second degree rape and third degree sex offense. And that's where the vaginal intercourse or sexual contact or sexual act occurs when the victim is either mentally incapacitated or physically helpless and therefore unable to consent. So it is not the case that we're only talking about fourth degree sex offense. We are very much talking about certain modalities of rape and sexual acts that include far more explicit touching, including digital penetration, penetration with objects. I want to close by saying I know there have also been discussions about the fact that these defendants could be charged with second degree assault. And it's true that they could be charged with second degree assault based on non-consensual sexual contact. And it's also true that if this bill passed and if a spouse were charged with fourth degree sex offense and second degree sexual assault and were convicted of both, the second degree assault would merge into the fourth degree sex offense, thereby reducing the defendant's maximum criminal exposure from 10 years to 1 year. Notwithstanding that, though, the Attorney General urges a favorable report on this bill because it's important for prosecutors to be able to charge a sexual assault as a sexual assault, even if it might result in lesser jail time. It should not matter what the relationship between the perpetrator and the victim is if, as is always required, the state can affirmatively prove beyond a reasonable doubt that there was a lack of consent for that sexual contact. So with that, I would say thank you for your questions. I'm happy to answer any further that you might have. And the Attorney General urges a favorable report on Senate Bill 250.
Thank you, Ms. Williams. We will next go to State's Attorney Braveboy.
Thank you very much, and good morning, Mr. Chair, Mr. Vice Chair, and members of the committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County, and I'm here to strongly urge this committee issue a favorable, report on Senate Bill 250. As you know, I've spent my career dedicated to ensuring that all Marylanders receive equal justice under the law. The current law, which allows marriage to serve as an absolute defense to rape, denies our citizens and residents that equal protection, and it cannot stand. The absolute defense also, allows perpetrators to sexually assault their spouses while they're unconscious, incapacitated, and also against their will. And just to follow up on Ms. Williams' point about second degree rape and third degree sex offense, it is not only required that you show force, but a second degree rape or third degree sex offense can be charged if the victim is incapacitated or helpless. So that is a very real issue that we are trying to address with this bill as well. And so we think that this bill corrects an injustice and provides protections to all victims, regardless of their marital status. This bill will allow state's attorney's offices an opportunity to review cases based upon the merits. And that's what we do in every case. We look at the merits of the case. So it's not an absolutely, we're going to charge something just because someone brings allegations to us. We have to be able to prove our case beyond a reasonable doubt. And the bar is really high for a reason. So I hope that that addresses some of the concerns that this will be misused, because again, our office has an obligation to ensure that we don't bring claims that we cannot prove. And so this bill, simply what it does, it provides our offices with an opportunity to review cases based on the merit rather than the merit of a marriage license. So that's why we're urging a favorable report of Senate Bill 250. And I'm happy to answer any questions you might have.
All right, thank you, State's Attorney Brayboy. We have one more witness, and then we'll open it up for questions for the panel. Mr. Smith. Is Michelle, sorry, Michelle Smith. Is Michelle, there you are, there's Michelle. Hold on one second here. There you go.
Thank you so much, Chairman Smith and Vice Chair Walsh-Streicher, members of the committee and the sponsors, Senators Lee and Walsh-Streicher. I am Michelle Smith. I recognize so many of your faces, and I'm glad to see you again this session. But I do see some new faces. So I will say, by way of introduction of myself, that I'm here on behalf of the Maryland State Bar Association, the Family and Juvenile Law Section Council. But I am a family law practitioner. And prior to that, for 20 years, I was a prosecutor in Anne Arundel County, and I specialized in domestic violence cases. So I do have some background, and I'd be happy to take questions in addition to the able-bodied AG and prosecutor that we have on our call. The Family and Juvenile Law Section Council of the State Bar Association strongly urges a favorable report for Senate Bill 250. Many of the comments that have already been made are shared in my written testimony, as well as what I'd like to convey to you today. I don't think that I need to repeat that this is an antiquated law and that our citizens no longer support it, and it needs to be repealed. It creates an injustice for married spouses who suffer sex offenses and rapes and cannot get full and equal access to the court system, which is simply not appropriate. I would like to address some of the questions about fourth degree sex offense. They have already been addressed, I think, very well. But I'd like to say that in my experience, for 20 years, I rarely saw situations that have been brought up here being prosecuted successfully. I myself would never have prosecuted cases that didn't have sufficient evidence. And I think most prosecutors and judges would find it very difficult to find somebody guilty, a defendant guilty of a fourth degree sex offense, when they simply reached over and touched the breast of their wife or the buttocks of their husband while they were asleep in bed. That simply does not rise to the level of what is required to prove that crime. We've talked a lot today about the consent issues, and I think those issues were addressed very well by the AG. But I also wanted to, I'm sorry? I also wanted to touch on the fact that a fourth-degree sexual offense also requires the proof that it was the sexual arousal or gratification on the part of the defendant. And that's a hard thing to prove in addition to consent. So there are barriers and protections to the concepts that have been raised here today. And I believe, and the Maryland State Bar Association also believes, that the committee we are urging a favorable report for Senate Bill 250, and I'd be happy to take individual questions.
All right, thank you very much, Ms. Smith. So I'm gonna unmute, I think, Ms. Williams and Ms. Brayboy, just so you're ready for questions of the panel. First question goes to Senator Huff. So Senator Huff, you're up.
Yeah, thank you. And I was just say, the reason why I think we're circling around this fourth degree is there's broad agreement. I don't want to speak for everybody, but on the other parts of the bill. But, I'm just looking at 3-308. And I'll go to the Attorney General's office. If you could answer for me, just to make sure I'm not misunderstanding. I'm just looking at the plain text of the law, because that's, our part. We write that, and then the courts come up with their case law and different interpretations. But all that I get from 3-308 is a person may not engage in sexual contact with another without the consent of the other. Is there anything else I'm missing on 3-308? I mean, that basically seems to summarize the fourth degree, correct?
Thank you for the question. I think you hit exactly on what you're missing, which is how the court has interpreted lack of consent.
Yeah, I just want to make sure that was all the text of the law, though. I didn't want to, I got the court. I appreciate it. I don't want to cut you off, but I know there's some questions. So I got the court and how they've done it, but I just want to make sure I'm not missing anything else to 3-308 or anything else.
No, the elements would be that you have to prove the requisite sexual contact and that it was done without consent, that there was a lack of consent, and that it was not a common familial expression or an expression of affection.
Yeah, we've not defined any of the case law or anything into that. I mean, just the plain reading of the law, I'm looking at our part, it's just all we've done is 3-308. The legislature's done is sexual contact with another without the consent of the other. That's all we've put in the law.
Right, and then the courts interpret what that means and what the requisite level of proof is to
Sure.
require a conviction on that. Mm-hmm.
Yeah, because that's kind of, because we go back and forth over familiar touching and consent and all these things. It was kind of interesting that the legislature's never gotten involved, and especially we're starting to dive into fourth degree. Fourth degree has always been tricky to figure out as far as when we're doing the sex offense laws and different things so maybe that's a topic for another day, trying to figure that out. But just one thing you said, that if you end up charging somebody with an assault and a fourth degree, you said the second degree assault carries a 10-year and fourth degree carries a 1 year, correct?
Yes.
And then you said if you merge the two, they end up only getting the 1.
Right. So do you want me to explain a little bit about why that is?
No, that's fascinating to me, because I think that's a problem. Another problem I didn't think about what we're doing. I knew fourth degree carried a lesser charge. What is the incentive then to have the fourth degree on there? Because on the punishment, you're going to lower the punishment. Is the incentive that you get them on like a sex offender registry? And what is the incentive on the fourth degree charge?
Well, I think and perhaps State's Attorney Braveboy would be able to discuss more about prosecutorial discretion when choosing what to charge. But this is one of the anomalies in Maryland law because fourth degree sex offense has an additional element that second degree assault doesn't. So all of the elements of second degree assault are subsumed by the elements of fourth degree sex offense. The second degree assault merges, even though the fourth degree sex offense penalty is much smaller. And I think when the state's attorneys or the prosecutors go to look at what they're going to charge, they look at many things, but one of them is, what is the penalty that the defendant is likely to face? And they weigh that against how important it is to charge a defendant with the crime that he or she actually committed. So there is value in charging a sexual assault when a sexual assault was committed. And if the prosecutor looks at the facts of the case and decides that it's very, very unlikely that a defendant would get more than a year in jail if he or she were convicted of the second degree assault anyway, then there is value in being able to charge that sexual assault, both for the victim, but also for criminal justice generally, because as you say, it's possible that that person could be on a sex offender registry, but at the very least, they would have the sex offense on their record so that people would be alerted in the future for public policy and public safety purposes that this person was convicted, not just of a second degree assault, but a second degree assault of a sexual nature.
Yeah, it's actually something interesting to look at. I mean, maybe we should look at that. And that's another bill about how we do that. Because we had a case in Frederick County. We had a doctor, and that happened where they ended up, because the way they merged them, the time dropped. I guess that's my last question for the state's attorney on this. Then, I mean, I've always looked at with these offenses that we're trying to get more time charged. I mean, that's if we're really going after an offense, we're trying to get more time on them. And one of the reasons, my understanding was, especially on the time, was that even if they didn't get the whole time, that they could be held on probation for longer because the sentence is longer. So, if they have another offense, even if they're not serving time behind bars, you have another offense, you can bring them right back on this other charge. So I guess I'm curious from the state's attorney's perspective why you want to go from a 10-year charge to a 1 year. I mean, aren't you worried about losing somebody's walking around the street with 9 years of backup time?
Well, I think the short answer is I think we would like to be able just to have all of our options available to us. And it is important that if someone has sexually...
All right, just 1 second here. The oath of office is about to be administered. So I'm going to toggle over. I'm going to share my screen. We'll share that and we'll come right back. Can you all see that?
Now we can.
Can you see it? All right, I'm just going to turn this up.
Please raise your right hand and repeat after me. I, Joseph Robinette Biden Jr., do solemnly swear.
I, Joseph Robinette Biden Jr., do solemnly swear.
That I will faithfully execute.
That I will faithfully execute.
The office of President of the United States.
Office of President of the United States.
And will, to the best of my ability.
Will, to the best of my ability.
Preserve, protect, and defend.
Preserve, protect, and defend.
The Constitution of the United States.
The Constitution of the United States.
So help you God.
So help me God.
Congratulations, Mr. President.
All right. Well, the peaceful transfer of power. All right, his speech is set to be 15 minutes, or we're obviously not going to stream the entire thing. So we'll toggle back to Ms. Braveboy. My apologies for the abrupt interruption, but I just thought it was important that we witness that.
Okay, now I'm unmuted. Excuse me. So I think what I was saying is that we would like all of our options to be available to us. And if you look at what is available, if someone is convicted of a sex offense, we can ask for a sex offender registry. We can ask for sex offender treatment, which we wouldn't be able to do on a regular assault case. So I think just being able to have all of those options available to a prosecutor's office is extremely important.
All right, Senator Hubbard, any follow-up? Okay, got it. I thought I saw a hand up with Senator West is next, and then Senator Castley, and then I did see. All right, so Senator West, you're next, and then Castley.
I'm sorry, I briefly had my hand up, but then thought better of it, so I took my hand down. Thank you.
Oh, understood. Thank you. Moving over to Senator Castley. I'm asking to unmute you. There you go.
Thank you. Thank you, Mr. Chairman. Just trying to understand some of the testimony that was given. Are the folks testifying in support of this, is it your position that if two people having the past had a sexual relationship and they get in the same bed and they're lying there on Tuesday night, they come home Tuesday evening, they have dinner, they go to bed, the fact that they got into bed together, did that constitute consent right there? To touching of intimate areas when they got into bed together and they're married? Does that equal consent? Yes or no?
So
yes.
I think
Thank you, Karen.
Ms. Williams will answer that.
So the state has to prove lack of consent. So it's not so much that getting in bed is consent. It's that in the scenario you were describing where there was no evidence of lack of consent, either through the express denial of consent or an implicit denial of consent, which is evidenced by either resistance or the genuine fear of resistance, then there's no evidence of a lack of consent.
Yeah, but you're talking about evidence and what you can prove in court. I'm talking about what is criminalized. What have we criminalized? Whether, we criminalized littering, but it's almost never prosecuted because it's really tough to prove it, because we criminalize a lot of stuff that basically it's really tough to prosecute. So the issue is, what have we criminalized? And that's what I'm trying to find out. You're focusing on how hard it would be to prove the case. I'm focusing on what conduct is criminalized. So, and I think to start off with that, I need to know, did that constitute consent? When they lied down together that evening, was that consent to touching of intimate bodily areas?
No, but what you're criminalizing is a lack of consent. And
what we're criminalizing is a 4th-degree sex offense, which is a touching without consent. Without consent, right? But I'm just trying to understand, when does consent? You're talking about what's the proof? What do I got to come in to prove consent or lack thereof? And I'm just trying to understand when, because the way I look at the bill is that you're saying, well, if you had sex before and now you went to bed tonight, I can assume that there was consent until the other partner says you no longer have consent. And I assume that's what you're saying. Otherwise, right? We're saying that if we've had sex, a relationship, and now we go to bed together, we lie down, that I can assume consent. So that consent has from the law, consent would have been given. And I realize they've fallen asleep now, but consent has been given. Is that right for 4th-degree sex offense?
I think it's a very factual, specific inquiry, but generally speaking,
no,
yes.
It's not.
I think Travis actually speaks to that, and I apologize for being a little bit unable to separate what you're criminalizing and what you can prove in court, because that's how we decide what proof is sufficient for it to actually be a crime. And Travis,
but you're again, you keep getting back to what's going in court. But we have to assume that most people are law-abiding citizens, and we don't have to be prosecuted. So when you criminalize something, you change our conduct. 99.9% of all Marylanders will change their conduct, and we're changing conduct here. And so, there's going to be the cases where we actually take them into court. But in the first case, we're actually outlawing conduct. And so I'm trying to understand, what's the conduct that you've outlawed that will probably never be prosecuted? Because as you say, these cases are going to be really tough to prosecute. Even if it's a bad case, it's going to be tough to prosecute, because you're probably in your bed, you're under the cover, or nobody else is there unless you're kind of perverted in your public sex. But so these are really tough. So let's go back to, what is the conduct that we are criminalizing? Because that's the issue. What conduct does the state of Maryland believe has been criminalized? And so I'm just trying to understand. When I look at this, I say that one of the conducts we're criminalizing is that if you reach over to you both go to bed at night at 10 o'clock, you fall asleep early in the morning while the other spouse is still sleeping, someone slides their hand over to an intimate part of their body. Why is that not a 4th-degree sex offense? Why is that not unlawful conduct? Unless we can assume that consent was given, that's been consented to. So, it takes me back to say, was consent given by the fact that you had an ongoing sexual relationship, and now you're in bed with that person? So you took your feet off the floor, you laid down, consent's given. Is that what we're saying?
Travis versus State says that's not good. That the hypothetical you're describing is not good enough to prove lack of consent. I'm not sure how else to answer that, except that that's what you're criminalizing. The courts interpret the words of the statute and decide what conduct is criminal.
Yeah, so I'm trying to find out for the other 99.9% of Marylanders, what is criminal conduct? And you keep going back to what do the courts have to prove? So when I go to the 99.9% of the people who say, oh, that's criminal, I'm not going to do it, right? So I'm trying to understand, what is that criminal act? And I got it. It's you're touching intimate area. The fact that you're married is no defense. You've touched the intimate area, and I want to know why in all cases, because it seems to me when I look at this bill, in every case, unless you affirmatively say, hey, dear, wake up, wake up, wake up. Would you mind if I slid my hand into X spot on your body, that now there has been no consent, and so I have just committed a crime? And a lot of people don't want to commit crimes. Whether they'll be prosecuted or not is not relevant. It's that their conduct is influenced by the law. So what I'm trying to figure out is, what is that unlawful conduct? So it's either that either I'm committing fourth-degree sex offenses, or my wife is, or the fact that we were lying there constitutes consent, even though she was asleep before. So I'm just trying to understand when I talk to my constituents and say, well, here is consent. What do I advise them to say? And not, well, if you went into court, it'd be tough to make the case. That's not the issue. The issue is, what is the unlawful conduct? And so the unlawful conduct is the touching of an intimate area, and it's done without consent or with force. The force is too easy. I smacked you to get there, whatever, okay, but that's a whole other case. But the fourth-degree sex offense doesn't require that. It just says you touch them. So I touched you without consent. So how do I advise my constituents that, well, and here's how you get that consent? Where is that? That's what I'm just asking. I just want to know from the sponsors, from the witnesses, where is that consent? Otherwise, this is like the sodomy laws where we said, well, you can't do it. Nobody was ever prosecuted, but we pulled those off the books last year because we just said we don't want that to be a public policy. So I'm just trying to understand, where's the public policy here? Where are we going? What can you do that's not against the law?
Well, as a supporter of this bill, let me just say that we're not here to relitigate the fourth-degree sex offense statute itself. What we're asking is that marriage not be a defense to a fourth-degree sex offense. That's simply what we're asking for here. So in the same scenarios that you're talking about, there can be individuals who've been in a long-term relationship, maybe even longer than some married people, and a fourth-degree sex offense could be charged, and there would not be any marriage defense to that, in those cases. So it's the same relationship in terms of intimacy. One has a marriage license, one does not. One can be charged, one has the ability not to be charged simply because they're married. That's really the essence of the issue here.
Okay, so and maybe that's what this all gets down to, is the intent here is just to say marriage licenses don't really mean anything. They're just a nice convenience. It's like a hunting license. You can have one or not, but there is no social value to a marriage license. There's no social value to marriage, and we're not going to treat that relationship any different than any other relationship. So I understand that some of the advocates.
Well, Senator Castley, I think what we're saying is that people cannot commit crimes just because they're married and get away with it. I think that's the better.
Answer my question. And when did you commit the crime? You're married. You're lying in bed. You're it's not your first day of marriage. You've been married for a while. Because whether you can convict us or not, it's a crime. And I want to know where the crime is. Clearly, if I say, can I touch you here? Or put in writing, can I touch you there? Clearly, that is consent. We would all agree with that. Now, absent that, where does the consent, at what point does the crime no longer exist because consent has been given? So you're not violating, you're not guilty of a fourth-degree sex offense. Where do I tell people, here is the standard now, so you don't commit a crime?
With all
Senator Castley, let me take a shot at it, if I may. I think what you say to your constituent is that they need to have consent. Anyone needs to have consent before they touch someone in an intimate area. And in America, each one of us has individual rights, individual relationships. We have the ability to associate with one another, and we develop our communication. So it is silly to say that you would need consent in writing from people who have been together for 30 years or even a day.
Okay, so
And
no one-
again, as State's Attorney Braveboy ably said, this is a question about what is the effect of marriage. And I'm sure you don't mean to be offensive by comparing marriage to a hunting license. But we do want to say that we respect marriage. There are, as of 2010, there were 828 people in Maryland living with an unmarried partner. They have more protection right now. In all of those 828 cases, those people could go to the state's attorney's office and say, I was touched without my consent.
Right.
What the law says right now is that marriage means you can't say that. Marriage is consent forever. It will be an automatic defense, no matter what the circumstances, no matter if you just had surgery in your intimate areas. This is offensive, and it is frankly disrespectful to marriage. So what you say to your constituent is, you need to know that you have consent. And if you don't know, if that's something that you're unsure of because of your individual relationship with this individual person, you need to take steps,
Yeah.
whether it's verbal or
And
nonverbal.
that's nice from your perspective as an advocate, but a crime occurs when a crime occurs, not because you subjectively think it did, or you wished it did, or it didn't, or your terms of your relationship. At some point you committed a crime. We used to outlaw sodomy, and everybody knows when that occurred. But nobody prosecuted for it, but it was there. And so we have conduct here that we're saying you cannot engage in. And you're saying, oh, well, it matters on the, no, it's criminalized. At some point, you had to do something to avoid the criminality of your conduct. And right now it's consent. And you're saying, well, consent is is sort of this nebulous concept. No, it's not, with all due respect. And you know, moving on, the example you give with the woman with the stitches. I mean, look, that was force. If she said, "Don't do that, I'm in pain," and you persisted, that was force. So that was an assault. It was not done with consent. So clearly, there's a prosecution there. So I realize, you know, there may have some judges may interpret stuff in a difficult fashion, but clearly that was with force. Clearly, it was without consent. And you know, that's not what we're talking about here. What we're talking about is if you're criminalizing conduct and nobody's able to tell me that here's when the crime begins, here's when it doesn't begin, because quite frankly, what this suggests to me is the only time it's not because it has to be with consent, that you actually have to wake the person up and say, can I touch you here? Can I touch you there? Or we can have sort of a bright line test that says, you know, either you got a marriage certificate or you got in bed, your marriage certificate, and you got in bed together and you laid down, and that's consent to an intimate touching. You know, this you know, bringing up these tough cases doesn't solve the issue of impinging upon people's freedoms because you've made conduct unlawful, and that's what you've done here. In my view, is we're making conduct unlawful that we have no public policy reason to make it unlawful. Thank you, Mr. Chairman.
If I could just interject, Senator Casserly, respectfully, you're mistaken about the use of force being existing when a person sticks his hand down somebody's pants without permission, and there's no resistance by the person for whatever reason. That's not enough to prove use of force in court. I just wanted to interject. The case law is clear on that.
No,
so
we were talking about the one with stitches. We were talking about the case.
Correct. That's not.
She said, "Don't touch me. I'm in pain," and he persisted. You're telling me.
Right. An express denial of force, of consent, excuse me, is not use of force.
Yeah. Well, it seems to me that the lack of consent there was pretty clear, because she has said, "Stay away. You can't come near me. I'm in pain."
I understand, and that would be one of the ways to prove lack of consent. But I just wanted to correct that for the record, because that the case law is clear on that.
Yeah.
All right. Thank you, Senator Casserly and the panel. Do we have Any more questions from the committee? Okay, seeing none, thank you all very much. And thank you, Senator Lee. And with that, that concludes the testimony and the hearing for Senate Bill 250. We'll now move on to our second bill of the day. Senator Patterson, I see you there.
Yes.
Senator Patterson, the floor is yours. Senate Bill 28.
Thank you, Mr. Chair and members of the JRP Committee. Good afternoon to all. First of all, let me just thank you for the opportunity to again speak to Senate Bill 28. This bill was before your committee last year, but we just didn't, we ran out of time in order to give it its full due process. But Senate Bill 28 is a bill that protects referees and umpires or a judge at a sport event from being physically assaulted. Under current law, if an officer does not witness a physical assault on a sport official, the officer is limited to report and refer to the commission a summons or arrest warrant. This has been an ongoing problem for sporting activities in Prince George's County, and through all the emails and texts that we have received, even out of state and elsewhere, it seemed to be a universal problem. So we believe it's high time to provide some type of protection for those who gather to carry out the goodwill of a community. And we have today 3 expert supporters of this bill who will, hopefully they're online. I see Cameron and should be Reverend Smith, Rodney Smith, and Mike Shippey are supposed to be on there. There are 3 of them. But anyway, they will speak more about the bill. They're considered experts. They were before this committee last year and spoke passionately about the need to implement a bill of this type. So, Mr. Chair, I'm not going to prolong it. I got a triple going right now. This bill, a hearing, and get down to my own committee for a public hearing, Zoom meeting per se. So I thank you for this opportunity to bring this bill before you, and we hope that you will give it a favorable response and vote this bill out to give us some protection in the sport arenas. And given that we're about ready to bring on another new avenue of sporting activity, sport betting, I think it even create more urgent need to address this critical issue. So thank you very much.
All right, thank you, Senator Patterson. I remember this bill and the testimony well from last year. So next we'll go on to, his first signed up was TC Cameron. Is TC?
Yes.
All right, TC, I'm going to unmute you. Your camera's off, but we can still hear your audio if you unmute yourself. Mr. Cameron. All right, while we wait for Mr. Cameron, we'll go on to Mr. Smith. So Rodney, I think I saw you here. All right. There you go. TC, there you are. The floor is yours.
Thank you, sir. My name is TC Cameron. I live in Annapolis. I've lived in Maryland, our great state of Maryland, for the last 12 years. Moved here from Michigan in 2009. And I'm speaking to you today because I'm a survivor of assault as a sports official. We are one of 24 states that do not have significant protection in place for sports officials. And I wanted to share with this group one of the many reasons that this is important. First of all, unlike when the Ravens or the Washington football team, the Baltimore Orioles, the Maryland Terrapins, the Navy midshipmen play a game here in the state of Maryland, they're afforded a significant protection. for them to work safely and without undue influence. And these officials come into our state from all different locales. Maryland, with its proximity to Pennsylvania, Delaware, Virginia, has a significant youth sports and high school sports and small college sports scene. And when these officials come in to work these games, they are afforded no protections. There are no protections at Stevenson, at Towson, at Annapolis PAL games, at Annapolis High School, Bowie High School, Broadneck High School, Easton, that could even come close to matching what professional and high college officials are afforded. And this is important because in the social media age, we've pivoted from a society that saw this behavior as obscene to one that now is reactionary and is over emotional, and they act first and they think second. When I was assaulted in South Bend, Indiana in 2006, I was chased off the field by 35 college baseball players, some of them swinging bats. And I was penned in between the field and my dressing room by these players and a parent who had run 300 feet to trap me. I feared for my life. And it was only 4 days later when someone thought to review the security footage that was on the side of a building that they revealed, you know what, I got the call right. The runner did touch third base. He was safe. The call was correct. And, oh, great, 4 days later, I'm right. But in the moment, I was in a fist fight. The police officers who responded said, well, we're not going to charge you, and we're going to give the parent an escort to the county line and say he not come back. Okay, that's great. Thank you so much for my black eye and my need to fight for my life, because I made a call in a college baseball game on a Sunday. So I want to share this story. I love the state of Maryland. I love our communities. I love that we have a very unique state that has cityscapes and urban landscapes, and we have country fields, and we have beachfronts. There's an officiating shortage, and officials at our level are voting with their feet. And the kids and the people who will be penalized if we do nothing are not going to be the officials walking away. It's going to be the children who want to play. It's going to be the high school level kids. And it's going to be the people who bought homes in communities and rent homes in communities who don't have these things that we all grew up with, because officiating has become an out of control avocation that people don't want to do anymore. That's the gist of my statement, and I will open the floor to any questions.
Thank you very much, Mr. Chairman, and thanks for sharing your story and sticking with this. We're going to take questions at the end of the panel. So seeing as Mr. Smith is not here, we're going to go to Mr. Schlip. Mr. Schlip, the floor is yours. I've asked to unmute you. There you go.
Good afternoon, Senator Smith and Senator Wall-Striker and the members of the Judicial Committee. My name is Mike Schulp. I'm the president of Baltimore's Best Umpires. This past March, as you know, my colleagues and I all testified before you on Senate Bill 1034, which was a law protecting sports officials. Today, my colleagues and I are here back again in support and passion of Senate Bill 28. It's time for Maryland to become the 24th state to pass a law protecting all sports officials against these assaults. We're here not asking for life sentences, or even life-changing marks of people's records. All we are is asking that a law holds them accountable for these actions that they choose to take. Senate Bill 28 will do that for us. Senate Bill 28 will give all sports officials the comfort and safety to do our jobs. My colleagues and I here speak and represent over 10,000 Maryland sports officials from Western Maryland to Ocean City, Maryland. Last year, I brought one of my umpires with me that was at the hearing. He was physically assaulted at a baseball game by a parent and a player. The police were called, they came to the scene. The officer could only write an incident report because he did not witness the assault. Senate Bill 28 will now give that officer with probable cause the ability to issue an arrest without probable cause, with probable cause, such as the video that we had and the 15 witnesses that witnessed the assault of my umpire. We're asking that this committee please give us a favorable review and make Senate Bill 28 a reality and protect each and every one of you and each and every one of us. We need it. Guys are quitting at an alarming rate, and you're going to turn sports events over to parents to start officiating games, and then that will become quite disastrous in these sports events for these kids. Senator Smith, I thank you for your time and your committee's time.
Thank you both for your testimony. So questions from the committee. Senator Heddleman has a question.
Thank you very much, Mr. Chairman. I guess I'm a little confused. And if you could explain to me, you explained the difference. I'm trying to figure out how this law, if it were to be enacted, would make an assault any different than if somebody came up to me on the street and pummeled me. I mean, can't sports officials still charge, or can't the police still charge someone with second-degree assault if someone is beaten up?
One of the issues that happens in these instances that happens at a field or a gym is that, just like my colleague mentioned, you have parents who are going to be loyal to parents, and they're going to say things like, it's really not that big of a deal. It was the heat of the moment, right? It's kind of like the concussion protocol with, he just got his bell rung. Well, this is a life-altering possibility here. It's more than you got your bell rung, and it's more than just the heat of the moment. When I was assaulted in South Bend, it had a profound effect on my career because my assigner looked at it and said, "Oh, I assigned you to a game and there was a fight. You must have done something." And the schools or the organization that's hosting the game, they don't want to see their parents suffer the consequences for their actions. It's kind of like what happens at 1600 10 days ago. Oh, you said these things, you did these things. Now you don't want to pay the price for what you did or said. You riled this all up, and you don't want to face the music for what you did, but everyone else has to take the brunt of it. There's no protection on the books for a sports official in Maryland. So it is different than you walking across Main Street and someone in the crosswalk punching you in the jaw. People look at sports differently, and they look at sports officiating differently. They say, well, what did you do to cause this? No, the official made a decision, and you're unable to deal with the decision, so you acted in this way, and there's no protection on the book for you as the official. So why does the official want to work in a state where there's no protection for him or her? That's why this is important.
So I should say too, I'm the mom of two athletes who were played 3 seasons of sports each year. And so I have seen the gamut, and I understand what you're saying. I've sat and stood on those sidelines, and I certainly know how my fellow parents can behave towards officials. So I'm not in any way excusing that. I'm just trying to understand really what this gets at if the protections are already available.
Think about what happens when you've witnessed that. Most parents don't walk up to that offending parent or fan and say, I'm going to use a generic name here, Mike, your behavior is really out of line.
Oh.
What they do is they they look down, they say, oh, this is bad. He's really riled up. Oh, we shouldn't be doing this. And then if it gets really escalated, at the door, they'll say, hey, Mike, come on, let this go. This isn't a big deal. You made your point. They'll give away these phrases that are supposed to calm the situation. The problem is when the police officer shows up, come on, this is much to do about nothing.
Okay.
And that's a big problem in our society today, is that we're not willing to hold people accountable. And I think if someone was held accountable, now someone walks over and says, hey, Mike, you read about that story in Silver Spring. You don't want to do this, buddy. You should really, this is just one game. Let's calm down. But we don't have anything like that on the books.
So you do think it would be used to diffuse situations?
Well, at some point we have to stand up and say, we're not going to take this. We're not going to accept this in our communities. We're going to put laws on the books to stop you from doing this. And at some point, word's going to spread around the campfire that, hey, this is serious. It also gives our youth organizations and our high school organizations an opportunity to speak to parents to point and say, this law's on the books, folks. You really don't want to go down this road. And I think that's the pause we need for people at the point of anger. Hey, stop. This is legit. You're in Maryland. Maryland isn't going to put up with this.
Senator Hedelman, if I can interject also, as the case I was talking about with my umpire, and last year when I first started this ability to get the law changed and had an opportunity to meet with several senators, I sent a copy of the video to the entire Maryland senators. Every senator in the state of Maryland got a copy of the assault that I sent. It was clear the father punched my umpire and pushed him into a dugout where he almost hit his head. His son ran up behind him and punched him. And when they realized that it was being videotaped and the police were called, the father and son fled the field and left. And then when the police officer got there, he said, because I did not physically see this, I can only write an incident report. It was up to the umpire then to go to the commissioner's office to get an arrest warrant issued. Where it came in is the program who the father and son belonged to would not divulge the name of the father or the son who committed the act. And to this day, they still will not tell us who they are. And so basically they've, even with a video, a 20-second video showing all this happening and 15 witnesses willing to testify, nothing can be done to that father and son for this incident. And this is why umpires are walking away. Umpires are quitting. They're tired of it. They don't, why go out and get $60 for a game when I got a chance that if I make a bad call, I'm going to be followed to my car, harassed, and potentially even have a fist thrown at me. It's happened to all of us in some manner. It happened to me years ago where I had a father charge onto a field after me. And when I stopped the game and had the police called, he was removed from the field after the game. He then proceeded to follow me to my car again. And at that point, nothing I could do other than call the police again. We need protection. Or again, what's going to happen is all those events you've seen at your children's games. Think about this. If that was a father from another team officiating that game where it wasn't someone who really understood what was going on, you put a father behind there and then watch what really happens. It's going to get uglier.
Thank you, Senator Hedelman. I know Senator Bailey has a question, so.
Thank you all very much. As being the father of 2 children that play competitive sports every weekend, I have seen some incidents that I do agree really get you to question what some parents are thinking. But the thing that I wanted to get to with this, being a police officer for 30 years, if what we're alleging, if it is a misdemeanor not committed in the officer's presence, the officers under current Maryland law cannot do anything. And it doesn't matter whether you are sports officials. If it was a spectator on the other side of the field, same rule applies. Okay, that is exactly what is happening. Now, that police department clearly will and should work with you to go to the commissioners so that you are allowed to file charges against that individual or the individual that did that. And they also are under a legal obligation to provide you with, when they conduct an investigation into a criminal act, to do a police report, to provide you with the name and people that were involved. So that is what I was getting to. I wanted you all to know that, and the other members of the committee, just because you are a referee or an umpire in a game, you are not afforded less than any other person that is there. The other thing is, if there happened to be one police officer in the stands, right? What one police officer sees, another one sees, right? So if there was even an off-duty police officer that saw what happened, that person, so obliged, could come up and tell that uniformed officer, yes, I saw it. This is what happened. And an on-scene arrest could then occur at that time. But I just wanted to make that clarification.
And you are correct, Senator Bailey. But when we spoke to the detective who then took over the incident report, they called the coach from the program, and the coach's response was, it was the first day that the young man showed up to play for me, and we really don't know his name, and we didn't have any registration on him. So again, that's where I come into, if somehow we had that protection. There was an incident in Frederick County just a year and a half ago where an umpire was doing a game up in Frederick, and a parent threw a water bottle and broke his nose, and the father took off. The police came, they went down the road, they stopped the father in his car and got his name and address, and said to the father, you're lucky, I can't do nothing about it now, but at least I have your name. So if we had this law that we're proposing now, that police officer could have arrested that father at that point.
All right. Thank you, Senator Bailey. All done? Or any further questions? Okay, good. Any other questions from the committee? All right. Seeing none. Mr. Cameron, you have something to say?
Thank you. First of all, I want to say thank you for considering this. Second, I would like to say that the job of a sports official, I think, sometimes gets missed in our day-to-day. Just imagine that you are anyone in this virtual meeting room is at a youth baseball game on a Saturday afternoon. On Friday night, you used your company tickets and you went to see the Orioles or the Nationals, and you had tickets behind first base, and you watch someone who gets paid $250,000, has had training, has proven they can handle the rigor and they have the acumen to do this job. And now it's 12 noon the next day, and you're watching someone who's 18, 19, 20, or they're at the back end of their career, 55, 60, 65, and they're getting paid $25 a game. And so you're applying what you see from your recliner or your box seats to this game that you're watching here. And you can't understand why this official either missed the call or got the call right, but boy, their mechanics just don't look as good as that professional official you watched. And that's where it starts. And when responding officers show up to these games, their job is to diffuse things. They don't want to make more work for themselves. They want to make less work for themselves on their shift. And so this is how it happens.
Mr. Cameron, is this in response to a question? I just wanted, if you could.
It is. It's in response to the senator and the thought that, you know, you do have protections. Yeah, on paper, you have protections, and they're the same as any other citizen. But at the field, in the gymnasium, those protections aren't always seen in the same light as they are on Main Street in Annapolis or at a shopping center in Bowie. What they're seen as is, all right, this is just a youth sports game. This happened. Can we move on? You know, and so these incidents continue to happen. And I think this is important to hear because we see this every day. I don't want Maryland to end up on YouTube video. That's why this important legislation, I'm hopeful, can be approved. Thank you.
Thank you very much. All right, seeing no further questions, that'll end the hearing and the testimony for Senate Bill 28. Thank you, Senator Patterson. Have a good day, and thank you both for your testimony today. All right, we'll now move on to Senate Bill 74, which is Senator Washington. But before we start, Senator Washington, just want to, as members, it's noon, it's past noon, so as members kind of go off screen and on screen, we're all here. It's just people are probably eating lunch and don't want to be on screen when they're kind of shoving their face. So just want to make that programming note that members are going to be on and off screen as they eat lunch since we're working through the noon hour. So Senator Washington, the floor is yours. Thank you for your patience today. Good to see you.
Good to see everyone. My old committee. Good afternoon, everyone. Chair Smith, Vice Chair Wallstrecker, members of the committee, thank you so much for this opportunity to testify before you on SB 74, a Police Officers Mental Health Employees Assistant Program. Before I begin, I want to note that you should all have a copy of an amendment that we made a request, that was actually made at the request of several law enforcement agencies that we've been working with over the interim, because you did hear this bill last year. The amendment is to strike the words mental health evaluations and insert resiliency sessions. And again, as you know, part of the goal of this legislation is to reduce the stigma towards officers who seek opportunities to repair their mental health and their behavioral health. The purpose of this bill is to require law enforcement agencies to develop and implement an EAP. That's an employee assistance program that's going to provide officers with confidential mental health services, including confidential services, crisis counseling, stress management counseling, mental health evaluation, and peer support. I believe this is an important intervention and discussion with the massive work that your committee has been doing around police accountability, around criminal justice reform, that this is an important component of that, the mental health of our police officers and law enforcement. This bill does not require law enforcement agencies who already have county-connected EAP programs to develop or implement an additional program. Those agencies would already be in compliance with this legislation. 2, it does, however, require law enforcement agencies to prioritize members' needs as it pertains to mental and physical wellness. These studies have really shown that it correlates with performance, and it also has correlated with excessive force. And also why this legislation is really important is that they are personnel, they are workers, they respond to, however, and witness some of the most tragic events our community has on a daily basis. This stress impacts their physical and mental well-being. The National Alliance for Mental Health recently published a study that showed that 25% of law enforcement officers have thoughts of suicide at some point in their life, that the suicide rate of police officers is about 1.5 times higher than the general population, that police die by suicide more than in the line of duty. I want to say that again. Police die by suicide more than in the line of duty. Compared to general population, law enforcement report much higher rates of depression, PTSD, burnout, and other anxiety-related mental health conditions. Another study by the Ruderman Family Foundation found that 35% of police officers experience PTSD compared to 6% of the general population. And about 12% of officers experience depression versus about 7% for the general population. In 2019, just have an example, a Montgomery County police officer, Thomas T.J. Boma, stood up on top of a parking garage and unfortunately took his life. Like Officer Boma, 25% of officers have thoughts of suicide, as I said earlier, on the job stress. And there's just this cumulative post-traumatic stress disorder that manifests over time. And untreated officers become at risk of themselves and others. Officers struggle with alcohol abuse, depression, suicidal thoughts, post-traumatic stress disorder, and other challenges. Now, despite the prevalence of mental health issues among law enforcement officers, there is a stigma in getting help. And again, this is what's key to this legislation. Many officers assume that asking for help is a sign of weakness. And if they acknowledge that they're experiencing some mental health challenges, then something is wrong with them. Many fear that talking about their struggles or seeking help will result in stigma from other officers, maybe some career setbacks and shame. Implementing an EAP would allow for officers to seek and receive treatment they need on a voluntary and confidential basis without fear of negative consequences. With programs such as this, we can provide our officers with the help while hopefully changing and, more importantly, reducing the stigma associated with mental health. We're going to recognize the need for this. Under federal law, the Law Enforcement Mental Health Wellness Act of 2017 provides funding for peer mentoring programs designed to enable law enforcement officers to get help from those who truly understand their experience and which is their law enforcement colleagues. This act recognized that law enforcement agencies need and deserve support in their ongoing efforts to protect mental health. Good mental health and psychological health is just as essential as good physical health for our law enforcement officers. At the state level, we did pass Chapter 519 to develop standards. I know I need to wrap up. What I'd like to do is at this time just introduce my panel, which is Mark Juckerman, a Harford County Sheriff, Vernon Herron, he's the Director of Office Safety and Wellness Programs for Baltimore, and then also David Morris with Riverdale Park Police. I just want to end by saying that I'm bringing forth this legislation because I was actually approached during a forum by a woman and a couple others who are family of law enforcement. And they asked for me to please work with others in the legislature to make sure that we're doing all we can to protect their families and also to support our law enforcement agencies. So thank you.
Senator Washington, thank you very much. And thank you for all of your assistance over the interim as we worked through the police reform package. And you've been dedicated to this. So thank you very much. And thank you for bringing this to our committee. This is great work. And not just because he's a Navy man, we're going to go first with Chief Morris. We'll go first. Here you go. I think you're unmuted. Should be good.
All right. Good afternoon, Mr. Chairman, fellow Navy man, and Mr. Vice Chair. Again, for the record, Chief Dave Morris. I'm representing the Maryland Chiefs of Police and Maryland Sheriff's Association in support of Senate Bill 74. We want to extend our thanks to Senator Washington for the thoughtfulness of and the approach in this bill and the inclusiveness that's been exhibited by bringing those that have the most at stake into the room. This bill recognizes and acknowledges that our law enforcement officers are human beings and that the potential for the detrimental effects of years of cumulative stress tend to manifest themselves in ways that are not typical within our larger community. Our law enforcement officers witness the worst that humanity has to offer, from homicides to the brutal sex offenses to domestic violence and child abuse cases that oftentimes leave the victims unrecognizable, even though these acts are committed by individuals that allegedly love the victims. Crime scenes that are often so horrific that they would rate a XXX rating in a movie theater because of the viciousness of the crime. This bill recognizes the value of the men and women that are not infallible robots to be judged by some sort of an imperfect metric, but human beings that have emotions and feelings, who laugh and cry and bleed and mourn, and sometimes display emotions that seem contrary to the situation, just as a means to cope with the reality of the inhumanity. This bill provides an avenue to assist those in law enforcement in establishing and defining and building resiliency in a discreet and confidential and empathetic and compassionate way, ultimately serving them in a way that will help them to better serve their communities. For that, we urge a favorable report, and again, extend our sincere thanks to Senator Washington for her work on this bill.
All right, thank you, Chief. And we'll now move on to Mr. Junkerman from Hartford County Sheriff's Office. Sorry about that. There you go.
Can you hear me, sir?
Yes. The floor is yours. Thanks.
Thank you, Mr. Chairman. Ladies and gentlemen, thank you for having me today. My name is Mark Junkerman. I am starting my 28th year of continuous service as a law enforcement deputy with the Hartford County Sheriff's Office. I've also spent more than a decade serving as a local, state, and national first responder wellness educator. I fully support Senate Bill 74 and would appreciate you considering passing this legislation. SB 74 will help to ensure that law enforcement members are offered a litany of voluntary behavioral health programs as a complement to the many mandatory requirements that are already out there. But for me, I believe it does more. I think this acts as a stepping stone, and it comes down to one word in my mind, and that's ownership. This bill makes officers recognize that they are people wearing badges and not a badge wearing a person. There should not be a stigma in asking for help. In fact, self-initiated requests for assistance should be the norm and not the exception. And to me, I call this a front end approach, or a left of bang approach, where we inoculate on the front end to prevent problems on the back end. Second, I think it demands members on a daily basis make a commitment. They need to recommit to the mission every day and to their purpose. They need to take ownership for themselves, and they need to be accountable to and for their peers. What we're doing is we're allowing our law enforcement professionals to make their own choices and their own decisions, frankly, before other people have to make them for those individuals. I think also, and sort of echoing a lot of the comments of the senator and of the chief, it encourages agencies to understand and embrace the fact that mental health doesn't happen in a vacuum. This mental health approach is extremely important, is a vital part of this, but this is about a holistic approach to wellness and resiliency. That's mind, body, and spirit. It's one that actually is designed to create a culture and not just a program, and one which is designed to help us select, train, and sustain the protectors our citizens deserve. Healthier people are going to be healthier cops. Finally, it reminds our society that investing in our guardians on the front end is going to pay dividends on the back end. What I hope this bill does is allow us as the frontline operators and leaders to take some ownership and to, for lack of a better term, have skin in this game, and to ensure that we are acting as the professionals that we want to be and that our citizens deserve. And I thank you for considering this bill, sir.
All right, thank you very much. We have a couple questions already populating, but Senator Jackson, I'm gonna wait till we get to the end of the panel, and then we'll come right to you, Senator Jackson. So next we will have Mr. Haran is from Baltimore City Police Department. You are up next.
Good afternoon. My name is Vernon Herron. I'd like to first thank Senator Washington for supporting this legislation. I'd like to acknowledge Senator Carter and my good friend, Senator Jackson, who had the privilege of working in the streets of Prince George's County with as a police officer. My name is Vernon Herron. I'm the Director of Officer Safety and Wellness for the Baltimore City Police Department. I'm honored here to be here today to testify in favor of Senate Bill 74. Prior to joining the Baltimore City Police Department, I served as the Public Safety Director for Prince George's County for 7 years. And prior to that, I served as a Maryland State Trooper for 27.5 years. As a Maryland State Trooper, I had the unfortunate incident of being involved in a police officer involved shooting where I had to use deadly force. At the time, the Maryland State Police did not have an EAP or any psychological support services. So I suffered in silence with PTSD. I had many sleepless nights. I turned to alcohol for relief, and I suffered for a long time until I finally reached out to a mental health professional who literally saved my life. In Baltimore City, we have an EAP that's accessible to our police officers 24 hours a day, 7 days a week. More than 60 police officers have come to us for help and have voluntarily signed themselves into alcohol treatment programs without being penalized and have now returned to duty. We have countless officers who reached out to our EAP for confidential counseling to deal with the stresses associated with police work. They were not penalized, and they're still working the streets of Baltimore City. I realize that my time is limited, but if I could, if I had the time, I would tell you of dozens and dozens of personal stories of officers who called me crying in the middle of the night, suffering with mental health issues, and we were able to provide them with the support they needed in order to continue their careers. I thank you for giving me the opportunity to testify in favor of this bill, and I will return the floor back to the chairman.
Thank you very much for your testimony. Next, we'll move on to Brandon Rubin. Is Brandon here? There you are.
Good afternoon, Chairman Smith and Vice Chair Waldstreicher. Thanks for having me. Good to see you and other members of the Judiciary Committee. My name is Brandon Rubin, and as a citizen of Prince George's County and an attorney at the Maryland Office of the Public Defender in Prince George's County, I speak to offer my support to Senate Bill 74. As I cited in my written materials, I just hope to point to some recent compelling research that was led by Professor and former police officer John Violante at the University of Buffalo. His work establishes empirically what has long appeared obvious intuitively, and that's that stressors unique and endemic to police work are associated with a wide variety of acute negative mental and physical health outcomes for officers. Accordingly, requiring law enforcement agencies to provide officers access to minimal cost mental health services is, in my view, an eminently rational solution to what's now a well-documented problem. And I also hope to bring a bit of a different perspective as a public defender. It's my view that the benefits of offering minimal cost mental health services to officers will, in all probability, extend beyond simply promoting officer well-being. In all likelihood, offering officers such services will benefit the citizens they encounter in the line of duty, many of whom become clients of the public defender. I mean, we know, unfortunately, that officer use of force or violence is too often not justified when compared against the conduct that stimulated the forceful or violent response. And mental health services, in all probability, would better equip officers to avoid unnecessarily using force or enacting violence on the human beings who my agency represents and for whom the officers are professionally responsible. Thank you, and OPD is in support of this bill.
Thank you, Brandon. Always good to see you. And you've done some great work, and I've published some good things in the Brookings Institution. So for the members of the committee, I'll make sure they get a copy of your writing. So just want to say
thank you, Senator. Thank you very much.
Thank you for being here. So now, Senator Washington, we have one more. Ms. Murphy is there. She is.
Thank you so much. Yeah, appreciate it. Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and the esteemed members of the Senate Judicial Proceedings Committee. My name is Jessica Murphy, and I am the state conductor for the Fraternal Order of Police, the Maryland State Lodge. I'm here to testify in favor of Senate Bill 74, which calls for voluntary and confidential EAP programs for law enforcement officers in this state. As a 22-year veteran of the Wycomico County Sheriff's Office and a board member of our local first responder peer support program, I've been wishing this day would come. I've been wishing this day would come as our police officers, they're hurting. They're hurting so badly that nationally 239 police officers took their lives in 2019, compared to 248 that were killed in the line of duty in that same year. This past year, due to COVID-19, we had a tremendous losses in law enforcement and throughout this country. No doubt the impact of such significant losses resonates back to 9/11 in regards to the 197 COVID-related law enforcement deaths we had in 2020. A loss of this significance always follows with despair, sadness, and metaphysical questions that we all have about life. As a result, and as a personal witness to the plight, despair, and isolation our police officers face on a day-to-day basis, I believe this bill is long overdue. Not many professions experience several real-life crisis situations in the course of one day. Studies have shown while a person in crisis eventually returns to normal within a short period of time, police officers have no such luxury. We experience the same crisis the public we serve experiences, and oftentimes we get to go to another crisis call on the same day. Sometimes it's the very next call we go on. We get no downtime. We do not get time to recover. Many officers turn to alcohol and others internalize their pain. Well, it shows up in a record high number of cardiac-related cases and deaths, but it just doesn't have to be that way. Senate Bill 74 paves the way to help police officers with their mental well-being by providing treatment options and wraparound services to include peer support and/or therapy. Most importantly, police officers are assured to receive help voluntarily and confidentially. When your job requires you to carry a gun, no one wants to admit they're suffering out of fear of losing their job. The number one thing I hear from officers and peer support is, I did not want to reach out for help as I thought people would think I'm crazy and I would lose my job. This job is all I have, and without it, I would cease to be me. Passing Senate Bill 74 will pave the way for our officers to seek mental health treatment without fear of losing their jobs. Therefore, I speak in support for Senate Bill 74 and ask that you vote favorably for this bill so we can provide voluntary access to mental health services, reduce stigma through confidentiality, and give law enforcement agencies what they need to continue or start an employee assistance program. You will be saving lives by doing so. Thank you very much.
Thank you very much, Ms. Murphy. Seeing no more panelists, so then we've got some questions. We'll first go to Senator Jackson, and then Senator Sidnor, I know, is in the queue as well. So Senator Jackson.
Thank you, Mr. Chairman, and thank you, Senator Washington, for bringing this piece of legislation forward. I haven't been and continue to be in the public safety arena. This is a vital piece of legislation. I'll say I have been lobbying Annapolis and Capitol Hill since the mid-90s. And I think now serving for the last 6 years, going on to 7 years, the most astonishing thing for me is coming from a jurisdiction, Prince George's County and the metropolitan area. We have been fortunate in some regards, but not in all regards, dealing with this matter. So my agency, the agency I grew up in, was honored to be the FOP president to look out for my folks and then be elected the sheriff. We had peer support and EAP and psychological services. However, that's still not enough. And I think that this bill, this legislation will bring forth an effort for the men and women who serve in this capacity to feel more comfortable to step out to say that, hey, look, I need help. It's better to have men and women draw to such a service versus going to the lodge or going to, turn to alcohol or other means. And for those of us who've been in this business for quite a while, be it military or public safety, we have that stigma. If we ask for help, we look as if we're weak, and we may lose our ability to carry a weapon going forth. So none of us want to deal with the unfortunate circumstances of our brothers and sisters committing suicide because of a lack of help. Senator Washington, I commend you. I've served with a number of the folks on your panel today. I think this is a huge step in the right direction as we reimagine what law enforcement looks like, and come full circle on ensuring that our law enforcement folks realize that they are a part of our community and they have the right to the same services we offer to our other government employees. So, Mr. Chairman, I'll just leave it at that, and I look forward to voting enthusiastically for this such legislation so that we can have a uniform service for our men and women who serve. Thank you.
Thank you. Thank you, Senator.
Thank you, Senator Jackson. And that's why we're just so happy to have you on the committee. You provide unique insight and background. So really, it's going to be good. Now, Senator Sidnor, you are next.
Thank you very much, and good afternoon. This question is for Senator Washington,
Yeah.
When on page 2, I'm looking at subsection E, and just wanted to, just for the record, to make certain that I'm understanding the intent. It reads, the employee assistance program required by this section shall include a component designed to protect the mental health of police officers during periods of public demonstrations and unrest. The word during is, I'm trying to make certain that I'm understanding what it is that you're getting at. That's all.
Can I get back to, I'm looking at that
And I guess what I'm trying to understand is there's something special that happens if there's a public demonstration and unrest, or is it?
I think what we're just trying to be is as comprehensive as possible. I'm happy to talk with you and talk also with the officers about, if there needs to be some clarity there, or if you think that it's weakening it in some way. I'm happy to talk with you about that. But I don't have a specific. I apologize. And we can.
No, that's fine. I mean, I agree with Senator Jackson. I'm looking at this and I'm surprised that this even had to be introduced, because I assumed that everyone had these EAP programs. So I'll be voting for the bill as well. So but I just wanted to make certain I understood what your intent is when we go into our voting session.
I'm just going through what we're thinking about. I think it just was made so we that we just thought to be specific, but it's not meant to be exclusive.
Okay. Look, thank you.
Thank you very much, Senator Washington Sidnor. Mr. Haran, I saw your hand go up. You wanted to chime in here?
Yeah, so I can say that in Baltimore City during the civil unrest, our officers were not allowed the opportunity for breaks. During and after the protest, they were not afforded the opportunity to meet with mental health counselors. That is one of the DOJ compliance directives that we have to comply with. So right now, during any protests, our officers are provided peer support during and after the incident has concluded.
Senator Sidnor has a follow-up.
Yeah. And I appreciate that. I didn't know that either. I'm curious. I mean, what was the reason for prohibiting people from getting a mental health break in essence during the middle of something like that going on?
Senator, great question. Listen, in law enforcement, we're still living in the dark ages where if you express that you have a mental health issue, we're going to suspend you, take your gun, your badge away from you. We're not seen as regular citizens that have these issues. So we're moving into the new age where we're recognizing that officers have issues and they need help. I had an officer call me one night crying, and I know he was about to commit suicide. And I was able to talk him to going to get some mental health treatment that night. And the question he asked me broke my heart. He says, I'm going to do this, but am I going to lose my job? And I assured him he was not going to lose his job. He went and got the help. He returned back to work. And just recently, this officer got promoted to sergeant, and he is now working with other officers who are struggling with mental health issues.
I'll share. My uncle was a retired homicide detective out of Baltimore City. And I can't imagine, given the things that he's had to deal with over the course of the decades that he was with Baltimore City, how the trauma of the things that he had to see and work with and how it affected him. Again, I'm just surprised that we didn't already have this. So thank you.
And with our new EAP contract, we're going to be reaching out to retired members and give them the same resources that they didn't get when they were officers. So thank you very much.
Thank you.
All right, fantastic. Seeing no further questions, thank you all. Thank you, Senator Washington, for this, and thank you all, the panelists, for your service and for your time today. This is great.
Thank you.
Thank you all. Have a good one. Stay safe.
Thank you.
With that, that'll conclude the testimony for Senate Bill 74 and the hearing for Senate Bill 74. We'll now move on to Senator Kramer, Senate Bill 122. Senator Kramer, you're up.
Thank you for that, Mr. Chair. Good afternoon to you, Mr. Vice Chair, members of the Judicial Proceedings Committee. Good to be with you this afternoon. You all have already had a long day. Ben Kramer here introducing Senate Bill 122. And colleagues, many of you know that in my time in the legislature, a lot of the work that I have done legislatively has dealt with issues of animal welfare, and in particularly the welfare of our companion animals, basically our fur babies. And the reason for that is simply that I believe the way we treat animals speaks volumes about who we are as humans. And the fact of the matter is our companion animals, our dogs and our cats, are entirely dependent on us for their care and their well-being. So in that regard, let me tell you what the bill does, and it's not particularly complicated. The bill provides minimum common sense protections for shelter for a dog that is left, and this is the operative word, unattended outdoors for greater than 30 minutes in temperatures that are either below 32 degrees Fahrenheit or above 90 degrees Fahrenheit, or in the event there's a National Weather Service active weather advisory. There's going to be a hurricane or a blizzard. That's what the bill does. And the shelter is prescribed in the bill as to what these minimal shelter requirements are. And quite frankly, there are already 11 jurisdictions in the state that have these standards in place or greater standards in place. And this legislation will not preempt any of the local laws that currently exist. So if a jurisdiction has greater standards, they remain intact. There were a number of changes that were worked through on this bill when it was prepared last session, and that was to ensure that people who, were sports people or hunters, whatever the circumstance might be, were protected from this legislation and not unintentionally pulled in. So if Vice Chair Waldstreicher has harnessed up his huskies and he is going out in that Montgomery County tundra to mush them, it isn't a problem. He can do that. But the intention of the bill is to address those individuals who are careless and reckless and thoughtless, and they leave their loving companion animals out in either bitter cold conditions or extremely hot conditions without any shelter of any kind. And it's sad that we need to introduce this kind of legislation and promulgate these kinds of laws, but the fact of the matter is, we have people who do this and allow their family pets to suffer and die. The poster pup example for this happened a couple of years ago in Baltimore County, where a ruthless homeowner left there, and I believe it was a French bulldog named Oscar, if memory serves me correctly, outdoors for an entire day in bitter cold snowing weather, and the dog simply died of hypothermia. And it's tragic and a horrific thing. So the purpose is to give a little bit of opportunity for our animal welfare folks to be able to address these folks who are careless. And real fast, if I may, because this is not my committee, I won't be able to address written testimony that's been submitted to the committee, but I believe overall everybody has supported it. I'm unaware of any opposition, but there was a letter from the American Kennel Club seeking perhaps a couple of amendments to the bill, and I'd like to quickly address those. One of those amendments states that they recommend language be added that considers age, breed, general health and condition of the dog, and its ability to withstand the environment. I would proffer to the committee that that would render the bill unenforceable, as these are all arbitrary terms, and anybody who is recklessly leaving their dog outdoors to suffer could simply point to, oh yeah, but you know what, the age, it's 3 years old, that makes it okay. Or, hey, the dog's in great general health, that makes it okay. So the bottom line is, I would ask the committee, please do not adopt this proposal. And then finally, they also make reference to, once again, a term that would render the bill useless, and that is that language be added with regard to acclimation, so that somebody could simply say, yeah, my French bulldog died out there in the yard after 6 hours in 30-degree weather because it was being acclimated to the winter weather. So I would ask you to please pass the bill as it is before you. It passed the House overwhelmingly last year. The House bill hearing, I believe, has already happened. If not, it's happening this week. So I would ask, Mr. Chair, members of the committee, please afford a minimal amount of protection to our companion animals by quickly passing this bill. Let's get it over to the House. And I thank you very much for your time.
Thank you, Senator, for this comprehensive testimony. I know Senator Wallstreicher, Vice Chair Wallstreicher, was particularly appreciative of the record there. So we'll take, I see Senator Cassidy has a question, so we'll do questions for the sponsor from the committee, and then we'll move on to the panel. So Senator Cassidy, go ahead here.
Thank you. And look, I don't have any, for the most of the bill, my only concern is that, I mean, certainly on the cold side, this seems totally appropriate. Dog can freeze pretty easily, but on the 90-degree Fahrenheit, that's most summer days in Maryland, and so many people just put the dog, chain them under the backyard under a big oak tree when it's 90 degrees outside, and it works pretty well. You put a bowl of water out there, and they can stay out there for an hour or two just hanging out because they don't want to be in the house. But you're going to say no, that you got to have people whose dogs live in, sleep in the house at night and are totally family members would still on a 90-degree day in July or August put the dog out under the big oak tree in the backyard, just let it lie around out there. And so I'm concerned about that, those cases. I mean, the kids hang out when it's 90 degrees outside under the big oak tree. So aren't we kind of being a little bit too stingy or too stringent here with the 90-degree?
Senator Cassidy, thank you for that question. And I think that's exactly the point. First of all, it is not ideal to chain any dog outdoors for lengthy periods of time. And we know that that absolutely can breed aggression in a dog. But the bottom line is there are statistics that show within a very short period of time, even less than 30 minutes, that dogs, just as humans can, when exposed to excessive heat, and 90 degrees is excessive heat, can quickly start to begin exhibiting signs of body shutting down. And those numbers, I believe, even begin in the low 80s. So we would not want someone putting a dog out, chaining it to an oak tree and hoping that by virtue of the dog maybe being able to find some shade under that oak tree, not succumb to the heat. The bottom line is these are minimal standards for shelter that allow the dog to get out of the sun, get out of the heat. And the last thing we want is for somebody who is not a responsible dog owner chain up a dog and say, hey, we were hoping it was going to find the shade under the oak tree and now the dog is dead.
I got you, but you know what? You're going to just force a lot of people. I mean, this is like the doghouse manufacturers thing, because a lot of folks, I will take the chain out of there. You got to, people fence their backyards. You got a fenced backyard with lots of shade in it. You're going to force people to buy a doghouse to sit it there, knowing that your dog never goes to the doghouse in the summer. They're going to lie under the tree somewhere, because why the heck would you go into a doghouse? Because there's no airflow in a doghouse in the summertime. So we're going to force people to buy a doghouse, sit it in the backyard. And you know, a lot of folks, it's no cooler inside than out. If it's 95 out, it's 95 in. There ain't no, the dog's not gonna do any better inside than out. There's no occasional breezes. So I mean, you know, a lot of folks don't live in air-conditioned homes, and I'm just not following why we were gonna force people to go invest in dog houses to stick in the backyard, knowing that a dog is never gonna go in that doghouse. And that's just in the summer months. I'm totally with you on the winter side, but this is. It's like a, you know, your doghouse manufacturer's dream bill. So thank you.
Well, and I appreciate and thank you for that. And the reality is the simplicity of what is required under the bill wouldn't necessarily necessitate somebody buying a doghouse. But the fact of the matter is a doghouse would be a nominal investment for someone who deems themselves worthy of owning a dog and accepting the realities of what comes with dog ownership, and that's responsibility. And that's what this legislation is about. It's about responsibility. If you want to take on those responsibilities, there are certain things that come with it. But thank you, I do appreciate your thought.
All right, Senator Castley, that's good.
Yeah, that's fine. I'm fine. Thanks.
Okay, got it. I think, does Senator Carter, do you have a question? No. Okay, got it. Looking around the Zoom room, no further questions. Okay, thank you, Senator Kramer. We'll move on to your panel. First, we have, is Patty Crankshaw Quimby here? Sure is. Patty, where are you? There you are. Okay, I'm gonna ask on you. There you go. How are you?
I'm well, thank you, Chairman, Vice Chairman, and committee. My name is Patty Crankshaw Quimby, and I'm coming to you today not only as the Chief Animal Control Officer and Executive Director of Talbot County and Talbot County Animal Control, but I am the President of the Professional Animal Workers of Maryland, and we are the state organization comprised of animal control agencies and humane societies within Maryland. We stand in unanimous support of Senate Bill 122. I submitted to you written testimony, but I just want to emphasize a few points to you. This bill is placing safety as a priority by requiring minimum standards for all pet owners in Maryland. Extreme weather, when we're talking about, Senator Castley mentioned 90 degrees, these recommendations are not even as strict as the recommendations of the American Veterinary Association or the Humane Society of the United States. They consider that at 85 degrees, animals could be in danger. As far as a doghouse in the summer, that's not necessarily a need, but protection from the weather, protection from the elements is what we're speaking on this bill. Requiring dog owners, regardless of breed, age, size, to ensure that they have safe and appropriate shelter and protection is all that this bill is asking of us. And even though my county is one of them, over recent years, several jurisdictions have created our own extreme weather ordinances. More than half of the state does not have such protections for the animals, which gives law enforcement, they are lacking any kind of teeth to protect the most vulnerable animals in our communities. This bill is really addressing those animals that are chronically left outside, not those of us whose dogs enjoy being outside when it's snowing for, you know, an hour to play, or who like to be under the tree in the backyard during a nice summer afternoon. The members of our organization, which is actually comprised of 80% of the animal control units and contracted shelters in Maryland, stand in unanimous support of this bill. And we truly hope that you give a favorable vote for Senate Bill 122. And I thank you for your time this afternoon. One of our panel members could not be with us. She had to leave at 12:30, Deb Stone. So Jennifer Bevan Dangle of HSUS will be touching on her main points. You do have her written testimony.
Okay, thank you very much for that. And so then we'll go on to Ms. Radoff. Lisa, you are next. There you go.
Good afternoon, Chairman Smith, Vice Chairman Waldstreicher, members of the Judicial Proceedings Committee. Thank you for the opportunity to testify before you today. My name is Lisa Radoff, and I'm the President and Chairman of Maryland Votes for Animals, here in support of SB 122. A statewide law with clear guidelines can foster both public awareness and compliance, which could potentially avert some of these life-threatening situations before they occur. When this bill was introduced last session, there was a question whether this bill could jeopardize or weaken requirements in local jurisdictions. So language was added to ensure that in these cases, local regulations would take precedence over state law. That last session, the hearing for this bill in this same committee was on March 10th, 2020, just 2 days before the announcement of the changes to the 2020 session, leaving little time for discussion in this committee. The House cross-file of this bill last session had widespread support and passed 125-7, but ran out of time. Last week, this bill was heard in Environment and Transportation and had a very successful hearing, and wink, wink, I've heard is coming out of subcommittee. Let's make 2021 the year that we finally give these unattended dogs who are suffering outside in extreme weather some protection. I would like to thank Senator Kramer for his sponsorship of SB 122 and urge a favorable report. Thank you.
Thank you very much. Always good to see you.
Same.
And next we'll move on to Ms. Bevan Dangle. You are up.
Thank you, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the Maryland State Director for the Humane Society of the United States. I do want to reiterate Ms. Quimby's point that this bill is really targeting these chronic abusers who are leaving animals unattended in all types of weather with completely inadequate shelter. This is a minimum standards bill. The current law is so vague that it is completely unenforceable, and it leaves dogs exposed to suffering and even death. Ms. Hess apologizes that she had to leave before she could testify. You do have her written testimony, and Senator Kramer referenced the dog that she would have spoken at length about, Oscar, who very unfortunately passed away in the snow because he was left outside day after day. One piece that I find really powerful from her testimony that I do want to share on her behalf. So many of you members of the committee are pet owners. Imagine if your dog died outside in the heat or the snow because it was unattended and could not advocate for itself. My children are outside in all types of weather, but they have the ability to open doors, bring themselves inside, drink water, and get the care that they need to regulate their body temperatures. As Senator Kramer mentioned, our pets are reliant on us to make these decisions for them and to protect them. And it's on us and on the state to make sure that our protections are sufficient to keep them safe. I do want to stress, as Ms. Radoff had referenced, this bill was amended extensively last year. I think actually Senator Kramer also went through some of the other amendments. This is not the first time the legislature has, brought this issue up and really deliberated on it. We were happy with the amendments that were introduced. We felt they were strong compromise amendments. We do resist the further amendments by the Kennel Club this year to further weaken the bill because we think we'd be back in the same position where it would be unenforceable. But thanks to the hard work of this committee and your House counterparts, the bill is at a point where this is the year to get it done. We are so grateful for your consideration. We're grateful for the bipartisan support we saw in the House, 125-7, I think was the floor vote that the senator referenced. And we really look forward to moving this bill this year to make sure that our dogs are no longer left in the suffering that they're currently exposed to.
Thank you very much for your testimony. So that concludes testimony for the panelists, but we do have some questions from the committee. Senator Huff is first, and then we'll have Senator Casserly.
All right, thank you. And like I said, I just have some questions about the bill. I think that were similar to last year. And I say this with my dog looking at me right now because I was eating my lunch and he's still here looking at me. So, so the current law is, I mean, the current law is, as you said, it is somewhat vague, but I would think there is something good to be said about that, because I'm looking at the current law in that your ability to charge or go after people. And I guess the concern in the past has been to make it more specific could actually make it harder. So, because right now, reading at that if you keep a dog in unsafe or unsanitary conditions, or that you cause injury to the dog or restraint. So I guess under the current law, if you're keeping a dog outside in the cold, how is it not fall under number 4, unsafe or unsanitary conditions, or 5, causes injury to the dog?
I'll unmute the, there we go.
Thank you. I'd like to speak to this specifically as a county that has a law very similar to this that we passed 2 years ago. This has allowed us to give people a baseline of what they need to provide. Excuse me. It is allowing us to say, when the temperature hits this, if an animal is out for this or this, you must provide this. It's very difficult to get people to understand these things until something has happened. This is a law that will prevent the suffering, because at a certain point, they must provide proper shelter. Here in Talbot County, it has allowed us to have our community, they now know what they need to provide, and they're doing it. So we're seeing less cruelty complaints and less calls. Excuse me. And when we are going out, people are listening and following through and raising the bar to where they're providing the minimum standards at a certain point. When a law says, if you do this, this, or this, it's more of a penalty once an animal has suffered versus helping the community be better for their pets.
I guess I just don't. Right now, it's 90 degrees Fahrenheit. Let's say, as an example that we put in there, very specific. So under the current law, if you leave your dog out in 89 degrees all day, it's kind of up to your all's judgment to say you left your dog in unsafe conditions, or that you could charge them. Whereas being more specific says, nope, it was 89, 88, and 90 is this. So you see what I'm saying? Is that having the state make it more specific? It seems like it makes it harder to charge. The more vague the law is, the more easily you can charge.
I think perhaps we look, as law enforcement and animal control, we look at things differently. We don't want to have to charge. So we want a law that protects the animals so that the public knows what is expected of them. If I go to a home and it's 85 degrees and an animal is suffering and I have to have it transported to the vet, those people are still going to potentially be charged under 10604. If I go out and it is 95 degrees and they have not provided what they need, and at that time, say we have a complaint, the 85 degrees. Although in my county, 85 degrees is where these protections have to be enforced, actually. So 85 degrees, and we say, look, your animal's out. These are the things that you have to provide if it is 85 degrees or higher. So under the state law, 90 degrees or higher if you're in a different jurisdiction. This tells them exactly what they have to do and what is expected of them as pet owners. And in order to prevent us from having a dog that died in a hot car, or having a dog that died out in the backyard at, freezing cold temperatures, this is giving them, law enforcement, the teeth to say, this is where you have to provide certain protections. It does not override or undermine our other laws, but this gives us more work, more teeth to do our jobs here in the state of Maryland. And we want a more humane state. I think the fact that all of our membership, 85% of the shelters and animal controls are behind this bill speaks volumes. We don't always agree on everything, I'll tell you that. We don't always agree on everything because it goes both ways, but I think this speaks volumes.
Well, just to, I guess, just ask another question though. So we would set a floor, you're saying, as a minimum, that this 89 degrees. But it does seem, and the argument is, well, right now in the statute, on the state statute, you could go charge, you'd have to make a case, I guess, but you could charge 80 degrees on the state statute. There's no temperature whatsoever. It's basically up to y'all. You could warn the person, you could charge whatever. I guess I'm worried about there being a conflicting, what people are told, because we have a state law 89 and then the counties are all doing 85 and 80. So I don't know, it just gives me pause. It gives me pause with the state, our over involvement. I think sometimes the state's over involvement too in a lot of these local things has caused confusion. But I guess that's my concern is I just don't understand how we're not weakening the law, because it's very vague now and allows you to charge. But I guess that's it. Thank you.
And if I may quickly, Senator Huff, and I appreciate your point, but the reality is we have literally thousands of laws where there is a local standard and a state standard. And historically, the rule is the state law sets the minimum, the floor, and then local jurisdictions have the opportunity to raise the bar. And the goal here is to acknowledge that we need the floor across the state. And then if local jurisdictions choose, as they always do, to have something that is greater, that's permissible. But the bottom line is this is about establishing the floor. And also with regard to the other comment, and I'm not gonna keep talking about it, but yes, they can be prosecuted under other state laws, but this gives, and the goal is not to prosecute, by the way, under the bill. First time it happens, it's a warning. It's, hey, listen, your dog's suffering. Here's what the law says. And hopefully now you'll abide by the law, because there's no excuse for you now to allow your dog to continue to suffer. Now, if it turns out it's suffering and it's not within the boundaries of this particular legislation, then yes, there may be other opportunities to address it. But as was mentioned, this creates clear boundaries for bare minimum care standards and protection in the weather.
All right, I'll look over. I just, that's my concern about being overly prescriptive, in that the broadness of the current allows you to really charge or warn or whatever people in a very broad settings, where if we get overly prescriptive, I get concerned that we're actually undercutting ourselves and going to have to come back every year and amend and change and add. But I'll look through it. I mean, we're all on the same page about wanting to help animals, just trying to figure.
Feel free to come visit me if you want to talk about it.
I know you'll find me.
All right. Thank you, Senator Huff. So now we've got a couple questions. I saw Senator West first, then Castley. Senator Castley, do you still have a question? You're still in line? Okay, then we've got Castley, then we've got Senator Bailey. So Senator West, you're up next.
Thank you, Mr. Chairman. So I'm concerned this bill is not only over-inclusive, but also under-inclusive. So on the over-inclusive side, I tend to agree with Bob Castley. If I were a dog, I would much rather be outside under a tree in shade, outdoors, where there's a breath of air, than be in a stuffy doghouse and sitting in the baking sun. So I suspect that this is going to make a lot of people buy dog houses when they know perfectly well the dog is never going to go in the doghouse. He's going to lie under the tree in the shade. I also think, however, it's under-inclusive. There's nothing in here about requiring water. I couldn't imagine having a dog lying outside all day long in 90-degree temperatures with no access to water. So why didn't this bill also require on those very hot days that the dog have some access to water?
Senator West, do you have a particular panelist that you'd like to direct a question toward, or just whoever?
Oh, why not let them scramble? Whoever wants to, who gets there first can answer it. Maybe, how about Jennifer? We haven't heard from her lately.
Oh, thank you, Senator. So other areas of state law and state statute already do require water to be provided to the dogs. And that's actually codified, I believe, in almost every single county law as well. That's why it's not included here.
Okay,
And so
that's fine.
the focus here is that we have such a vague definition of shelter in the current state law, to a little bit to Senator Huff's point as well, that because that current law is so vague and unenforceable and unclear, people don't know what's acceptable, and law enforcement cannot take action when a dog is at risk. To your point, you know, we've got dogs and other animals, and sometimes they use their shelter and sometimes they don't, but they can't come to us and ask if they're unattended to be brought inside or to be put into a different situation when the weather, you know, is beginning to bother them. They're completely dependent on us to provide the basic shelter that they need, and then they can choose to use it or not, but that gives them the autonomy. My kids can open doors and come back inside, sometimes whether I want them to or not, but my dog can't do that. So that is the goal behind this bill.
Okay, great. Thank you so much.
All right, thank you, Senator West. So we have Senator Castley and then Bailey.
Thank you. So yeah, not to belabor this point too much, but it was stated that this didn't require a doghouse. I don't know what we would call it, but you must have a solid floor, a solid roof, 4 walls, and a doorway. I don't know, it sounds like a doghouse to me. So that I could not, in the warm weather, it would not suffice to put up a 20 by 20 tent with no sides on it. That would not be sufficient. I'd have to put sides up and put a doorway in it. Look, we're all trying to protect. It's just, I think the thing's written, you know, I'm totally in the spirit of where you're trying to go with this thing. I think we leave people a little bit of flex. You know, these standards are great for the cold weather, and no problem with that. But it just, I'm one of those guys who bought a doghouse, and the only thing that ever went in it was the kids. A very nice doghouse, plastic doghouse with the walls and all that nice stuff. The dog never, in like 10 years, never went in the damn doghouse. So, you know, they're not cheap, and we would never put the dog out unattended in the winter. So we didn't need it in the winter anyway. It was only in the summer because we don't do air conditioning. But I just think we need a little more flexibility, and maybe, I don't know if the sponsors are open to that at all, but I think in your standards you got are great for cold weather, but maybe we can provide a little more flexibility if it's just, you know, a 90-degree day, which is all of July and August, part of September in Maryland. Thank you.
All right, thank you, Senator Castley. We've got Senator Bailey.
Thank you very much. And this question would be for Senator Kramer. And I would just like a little clarification. Of course, I represent quite a few farmers. And in Southern Maryland, we have people that actually, you know, they've got, whether it be calves or goats or sheep or chickens or guinea hens, whatever on their farm. And they have dogs that be left out with those animals. And, you know, when we're dealing with coyotes right now, right, they are extremely optimistic. Or opportunist, rather. They would come in at any time that they would see those animals not protected. So the dogs would be out there with them at all times. And we talk about an exemption for actively engaged in livestock herding. So for a farmer, if he had, my question is, when we talk about establishing the bare standards, if he has any type of herd of animals on his property, then his dog would be able to be out all the time, is what I was getting to, as long as they had access to the same shelter that the animals had access to, and they would be with them, that they would be exempt from this. That's all I was checking on. Thank you.
Okay, so I'm not sure whether you just picked up in the bill that livestock herding is an exemption, or if you were asking, is it an exemption? But yes, under the bill, livestock herding is an exemption.
So what I was getting to was the term that it said they must be actively engaged in livestock herding, right? And I don't understand what that is, right? That would be for me, and my impression, having grown up right next door to people that had this, the dog was out 24/7. That dog would have actively been engaged because quite clearly, Coyote takes his opportunity whenever he sees it. If the dog's put back in a house somewhere and can't protect the livestock, then it's, it's not there. So that's what I was saying. If you had a farm and you have animals that are in a pen that have access to obviously shelter, a dog should be able to be with them 24 hours a day. And the only reason I bring that up is you said it's clarification for a minimum standard. I want to make sure that we're not making these people that have herds of animals, criminals.
No, and clearly that's not the intention. And clearly, I think our folks in animal welfare protection will tell you that that's not what happens. That's not a scenario that happens. The intention of the legislation is for those individuals who are careless about the care and well-being of their dogs. They stick them in the backyard and forget about them, and regardless of the temperatures. And this more or less is a family dog, not a working dog as you're concerned about. And quite frankly, the animal welfare people are not out there looking to say, gotcha, your dog was out there protecting livestock, but because of this law, we're coming after you. Clearly, that's not the intention, and I don't think under any realistic scenario that our protective services are going to be looking to do that. I see Senator Casserly, I don't see at the moment, but his reference to dog shelters, and while there you are, Senator. I wanted to tell you that I'm taking a look right now at Amazon, and I see a bunch of dog houses in the $50 range. And so, when you say it's some significant cost, and the bottom line is, if people are, in the state of Maryland, we get all 4 seasons. If somebody wants to put their dog out back, then they're going to have winter. And as you have already acknowledged, what may be appropriate in the bitter cold of winter may not be needed in the summer in your estimation. Well, the fact of the matter is they still have to get this $40 or $50 doghouse from Amazon, have it available. And then, yes, nobody's saying that the dog's going to have to be forced to stay in the doghouse, but at least the opportunity is there for the dog, if it chooses to seek shelter, to be protected. That's the bottom line.
I see Ms. Bevan-Dangle, did you still want to chime in here?
Thank you, Mr. Chairman. I just did also want to reiterate, Senator Bailey, to your point, most livestock is already required to have different types of shelter. I have sheep, they have a run-in shed. That run-in shed would be considered adequate for the dogs as well under this bill. So you're sort of doubly protected, both by the active, livestock herding language, and also by the fact that most animals, again, whether they're using them or not, because my sheep were out in the snow because they're not that bright, but whether they're using them or not, they do have to have the shelter available.
Okay, and that was my point exactly, because of the fact I've yet to see a lot of those that have floors in them. They're dirt, right? It's not a raised floor. And when we talk about making a minimum standard, right, that was the only thing I was getting to. And not that I would want to change anything, but I do think that if it's simply a working dog, I think a working dog exception across the board would cover things like that. Thank you.
Senator Bailey, your line of questioning did prompt me to Google guinea hen and beautiful birds. So thank you for that. Was a guinea hen. All right. Seeing no further questions. Okay, I think no questions around the committee. Okay, fantastic. Thank you, Senator Kramer. Thank you to all the panelists. And I'm sure we'll be in touch soon. So thank you very much. That concludes the testimony and the hearing for Senate Bill 112. We'll now move on to Vice Chair Wallstreicher. Senate Bill 159 is next. I think you have the next 2 or 3 bills here.
Thank you, Mr. Chairman. Members of the committee, before us now is Senate Bill 159. As many of you know, lots of professions have training and continuing education requirements. They do this to raise the level of expertise and professionalism within an industry. Animal control officers do great, important work in our communities, and they now want to professionalize their industry, and they want to do so by asking for a training and continuing education requirement. It would be 80 hours paid for a certification after hire, and then 6 hours per year thereafter. In other words, this is an industry looking to impose training requirements upon themselves. And with that, Mr. Chairman, I would ask for a favorable report for SB 159.
Fantastic. Thanks. We have your panelists. First, we have Ms. Crenshaw Quimby still here, so I'll unmute you. And the floor is yours.
Thank you. I will be quick on this bill. Thank you for having me speak once again. And once again, Professional Animal Workers of Maryland stands in unanimous support of Senate Bill 159. Simply put, there currently are no educational requirements for those entering the role of animal control officer in Maryland. While many of us have internal requirements for training, excuse me, there are those enforcing state and local laws with little to no formal training. The bill simply requires 80 hours of initial training and then 6 hours annually of continued education. The bill also allows for the details of the training to be determined by the agencies based upon the unique needs of the jurisdiction and our populations. Senate Bill 159 will raise the professionalism of the field of animal control and support our continuing efforts for public safety and best practices here in Maryland and in our field. Professional Animal Workers of Maryland respectfully request a favorable vote on Senate Bill 159. And I very much thank you for your time, and Senator Waldstreicher for presenting this bill.
All right, thank you, Ms. Crenshaw Quimby. We'll now move on to Mr. Coing. Thomas, see you over there. How are you today?
Yes, I'm here. Can you hear me?
You can.
Okay, thank you. And thanks for this opportunity to talk about something that's probably near and dear to my heart. And just so you know, we are no longer your mom and dad's dog catchers. The profession has evolved, and it's important to note that currently we have animal control officers throughout the state that have never received or benefited from formal standardized training, particularly at the start of their career. And what's important about this training is this is training by experts in the areas of criminal investigations, enforcement, animal care and handling, humane education. And they're not attending because it's not available to them. They're not attending because it's not required. So what I'd like to do is, looking at Senate Bill 159, it would correct this problem and ensure future animal control officers receive this much needed professional training. What I'd like to refer you to is our neighbors in Virginia who require all of their animal control officers to receive standardized training through a state approved program. It's in their state statute that, at least in part, I'll just read what it says. Every locality employing animal control officers shall require that every officer completes a basic animal control course that has been approved by the state. In addition to that, they've also provided for, as we do in the bill, the continuing education credits of 15 hours for animal control and protection over a 3-year period. What's consistent about Virginia, Maryland, and I'll refer to the National Animal Control Association, who also provides professional training. They provide experts that do professional instruction in animal cruelty investigations, the connection between animal abuse, child abuse, and domestic violence, all of which are now reportable by animal control officers. Legal research and resources such as constitutional law, search and seizure laws. They focus on professionalism and ethics, the collection of evidence and the chain of custody. Really important to me is case preparation. So officers are better prepared to testify in court. They focus on conflict resolution and officer safety, which also deals with the physical and mental well-being of our officers, very important to their work. They focus on animal disease principles and zoonosis and a variety of other topics I won't need to go into. Senate Bill 159 will help professionalize animal control as a career and then also support local governments' continuing efforts to employ best practices when it comes to responding to violations of laws and regulations. So the Montgomery County Office of Animal Services supports Senate Bill 159 and would urge adoption of a favorable report by this committee. Thank you very much for your time.
Thank you. And next we have Ms. Radoff. Lisa, how are you?
Fabulous, thank you. Chairman Smith, Vice Chairman Waldstreicher, members of the committee. I'm Lisa Radoff, President and Chairman of Maryland Votes for Animals, here in support of SB 159. You've already heard from the leadership and several members of PAWS about the need for this bill. We believe that this training will increase public confidence in these officers and the policies of local animal control. Because while they are not empowered to make arrests, animal control officers do have the ability to seize animals and issue citations as they enforce the laws pertaining to the animals in their county and the state of Maryland. People view their animals as members of their family. So when animal control officers deal with these types of sensitive issues, they need professional training. As the former owner of Gebco Insurance Associates and a licensed Maryland insurance agent for over 30 years, my agents and I had to pass a test to be licensed property and casualty and life and health agents in the state of Maryland. Every 2 years, we were required to complete 24 hours of state-approved continuing education. In short, I think that most Marylanders would say that having a trained animal control officer who knows what to do in a dangerous dog situation is at least as important as having training when your insurance agent gives you that binder number to drive your car off the lot. I would like to thank Vice Chairman Waldstreicher for this bill and hope for a favorable report. Thank you.
Excellent, thank you. And now we have Ms. Bevan Dangle.
Thank you, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the Maryland State Director for the Humane Society of the United States. You've heard much more eloquently than I can speak to the reasons why we need this bill. I just want to touch on one specific point that's important to keep in mind as you look at this. This is another piece of legislation that gives an incredible amount of local flexibility and autonomy in how they implement it, what types of trainings they seek, how many officers they send, when they send them, because we do understand that not all counties have the same structure or the same size of department. So this allows the counties to make sure that they can meet this requirement without putting the valuable work that these animal control officers need to do in any type of jeopardy. We also, reviewed this bill heavily after last March, and we're very confident that it would allow for virtual trainings, which, given the current state of affairs, we all hope that by the time this bill takes effect in October, that in-person trainings, we might all be desperate to go to in-person trainings by then. But should that not be the case, the bill will allow for virtual trainings as needed. So we just wanted to make sure that the committee was well aware of those 2 points, and reiterating everything else the other panelists have said, we urge a favorable report.
Excellent, thank you very much. And I believe that rounds out the panel. Looking around the room, I don't see we do have one, Senator Sidnor.
Thank you. Just one quick question. I'm trying to understand for something where you're looking for training, why this will be put in the criminal law code. Any idea, Mr. Vice Chair?
Let me pull this up here. Sorry, I've got so many bills open here. Yeah, I think the answer, and I'll defer to council when we discuss this at some later point, is that this is where they are empowered The animal control officers are empowered by our criminal law article, and so that's where this lands. But I'm happy to just, it does seem a little bit odd.
I was just curious.
Yeah, that's a really good question. We'll find out from council.
Thank you.
Okay, excellent. Seeing no further questions, that will conclude the hearing for Senate Bill 159. We'll next move to Senate Bill 91, Vice Chair Wallstreicher.
Thank you, Mr. Chairman. We are going to move off of our companion animals here and talk about something very serious, and that is our transit operators, our bus drivers, and our train operators. They have been working since March when the pandemic hit. They are important frontline workers, just like our police officers and our firefighters, EMS workers, and correctional workers. And just like those essential workers, transit operators are subject to a surprising and outlandish amount of abuse. We heard the other day about a passenger who ejaculated onto another bus passenger. Now, that wasn't the bus operator, but it does give you a feel for some of the bad behavior that operators see every day. Here are some examples where the operator was in fact the victim. A few years ago, a woman threw a full cup of her own urine at a Metro bus operator. And just a few months ago, MTA bus operator Marcus Parks was murdered in Baltimore. They fortunately found his murderer, and may the blessing of Marcus Parks be a memory to his family. Since the pandemic, this extreme level of abuse has only increased. Transit operators are now forced to enforce mask mandates, and some passengers refuse to wear masks or refuse to wear them correctly. This has resulted in shouting at, spitting on, and assaulting our transit officers. And now a new change has happened over the course of the last few weeks. As many of you know, during the pandemic, transit was made free so that people could enter buses in the middle door instead of near the bus operators. Now we know that bus operators have their PPE and can safely enforce the requirement of fares. And so people are now required to enter at the front of the bus once more. Well, as you might imagine, some people who were previously utilizing our transit operations for free are not so happy that they have to pay a fare again. And so once more, transit operators are being shouted at, spit upon, and assaulted. We need a remedy. We have previously separated out our police officers, firefighters, EMS workers, and correctional workers in our assault statute, and it's time to do the same for our transit operators and to say we value them. With that, Mr. Chairman, I ask for a favorable report for Senate Bill 91.
Thank you, Vice Chair Wallstreicher. Seeing no questions for the sponsor, we'll now move on to your panel. I have the first panelist, Mr. McMillan. You are up next.
Yes, thank you, Chairman, Vice Chair, and the committee. Thanks for this opportunity for myself, Mike McMillan, President Business Agent of ATU Local 1300, for the employees of the MTA and members of our great union. And also Senator Wallstreicher, thank you for this opportunity and bringing this to light. Thank you for the acknowledgement of our members and employees of MTA as being the front line. And as you stated, they are the frontline employees for the MTA. They're the eyes, the ears, and also the ones who the public first sees when something goes wrong with the transit system. Whether it's the public's own fault of missing a bus, or because of delays in service due to traffic or breakdowns, our operators are the first ones to get the blame for everything. They have to be the doctor on the bus when a passenger is not feeling well. They are a tour guide to people who need to know where they need to go from time to time. And also when other passengers are being assaulted by other passengers, they have to intervene. They have to call the police, and they're at times considered to be snitches. I operated a bus for 15 years and I operated this subway train for 7 years. And I saw these things firsthand happen and have had threats made towards me. Something that's very dear to me right now, as Senator Wallstreicher mentioned, assaults on bus drivers at an all-time high, and it has reached this point for Baltimore City at this time. My friend, co-worker, Marcus Parks, who was assaulted to the point of death, it was troubling for our entire membership and for the administration. And we have, enough is enough for it. And this has been a issue that has been brought to light by our previous leadership, the previous administration of the MTA, and we really need this bill to pass. I do feel that if this legislation was in place to make people think twice before they act in this manner, that my friend, an employee of MTA, Marcus Parks, would be here today. So ATU Local 1300, what we're asking is also we're standing by Senator Wallstreicher for support of this bill. Thank you.
Thank you, Mr. McMillan. Thank you for taking time to testify today. We'll move on to Clint. Mr. Silverati, there you are.
Hi, everyone. Everyone can hear me?
Yes, we can.
Yes, hi. Good afternoon, Chairman Mr. Smith, members of the Judicial Proceedings Committee. My name is Clint Silverati. I am a Vice President of UFCW Local 1994 McGeo, and I'm testifying in support of SB 91. Ride-on bus operators are frequently victims of assault and must be offered the same protection as firefighters, paramedics, probation, and parole agents. I've worked as a bus operator and a transit coordinator with Montgomery County Transit Department Ride-on for the past 10 years. I'm also served as a shop steward for my union. Over the years, I have heard and witnessed numerous attacks on drivers that have endangered not only the driver, but passengers and other vehicles as well. Right before COVID-19 outbreak, a senior driver was brutally assaulted, sustaining serious injuries to his face, swollen jaw, and a black and blue eye. The driver was relieved from his duties to recover and care for his injuries. Upon returning to work and back on his regular scheduled shift, the driver now must transport the man that violently attacked him. His assailant never faced serious repercussion, and this operator is petrified for his safety and his life. In another recent example, without fear of any real repercussion, a male passenger continuously harassed a female bus operator every day on her set scheduled route. This passenger threatened the driver daily, throwing objects at the bus operator, causing her to be distracted with a bus full of passengers. This passenger went as far as kicking and breaking the glass door to the entrance of the bus. The female driver was in fear of her life. She reported the incident and started to take time off from work to avoid any more interaction with the passenger. Being a single mother and a target of violence, this bus operator was contemplating a career change. I spoke with management regarding this issue, and we have devised a plan for me to follow the driver the next day and figure out who and why this was happening. The following day, the driver was too afraid to come to work and was unable to resolve the problem. Luckily, the driver was able to switch routes, but the passenger remains a threat. These are only two of many horrific stories that I could share with you. Just this summer, as my fellow colleagues just mentioned, a bus driver was killed by a passenger in Baltimore. And every day I'm afraid that this may happen to another driver. Transit operators are serving on the front line in a pandemic that has cost hundreds of thousands of lives. And we are the lifeline that keep the people employed, business open, and economy moving forward. It is incredible high stress and a high stake occupation that carries many obstacles, but assault should not be one of them. Attack on transit operators are increasing, and these are assault threatens not only the driver, but everyone on the bus, every other vehicle on the road. Please help us and the passenger who depends on our safe. On behalf of 8,000 members of UFCW Local 1994 McGeo, I am in favorable report on this legislation. Thank you.
Thank you very much, Mr. Soberati. Next, we have Mr. Neighbors, Derek Neighbors, my neighbor, one of my neighbors. Good to see you.
Yes, can you hear me?
Yes, we can. How are you?
Yes, I'm great. How about yourself?
Good. Good.
I'd like to, well, you threw me off base. Thank you, Mr. Chairman. Thank you for the opportunity to give a trans employee's perspective of SB 91 to increase penalties for assault on transit employees, all transit employees, not only the operators, the maintenance staff, and managers alike. My name is Derek Neighbors, an ETU Local 689 member, Metropolitan Washington Council, AFL-CIO, ICAR, ASC Certified Master Tech, AA Lead, Body Paint Graphics, Heavy Overhaul Mechanic, Shop Foreman for WMATA Metro. I'd like to reiterate all that the previous speakers have said, because normally in my shop, I receive the end result of these vehicles having collisions, cleanup, so on and so forth. We as trans employees have experienced assaults at an alarming rate. We are frontline essential workers, routinely experience verbal assaults daily. However, presently, there's an uptick in the threat being not only spit upon, but coughed upon using possible coronavirus bacteria as a weapon. Presently, front door loading and fare collections have begun again, which increases direct contact with the riding public and occasionally confrontations on required face coverings and possible distribution of K95 masks if available, because supplies have become severely limited. 2 weeks ago, during the Capitol riots, the metro system was in service 2 hours after the city curfew went into effect, leaving many transit workers in harm's way. Many of the unmasked, out-of-control riders use metro rail stations to get to and from the Capitol, where metro station personnel are required to stand outside the kiosks. Many of them came in close contact with, not only risking coronavirus infection, because the riders, for the most part, didn't wear masks, but bodily harm as well. I ask in closing to increase penalties and pass SB 91 to protect transit workers performing their official duties, as is the case of law enforcement, firefighters, or other first responders in emergency situations. I hope this bill will become law to protect essential workers who also transport many other essential workers, continuing not only to move the city, but get it done in a safe manner under protection of law. I'd like to thank Senator Waldstreicher and McCray for sponsoring this bill. Thank you.
Thank you very much, Mr. Neighbors. Give Carla my best.
I will. Camille as well, and Jacqueline.
Yeah, there you go. Thanks. So Mr. Quinn, you're up next. How are you? Good to see you.
How are you? Good to see you too. So thank you, Chairman Smith, members of the committee, for allowing me to be here today. My name is Kevin Quinn. I'm the administrator of Maryland Department of Transportation, Maryland Transit Administration. I'm here in strong support of SB 91. First, I'd like to say I greatly appreciate the efforts of Senators Waldstreicher and McCray for their advocacy on this issue. Thank you so much. This legislation increases the penalty for causing physical injury to any individuals providing public transportation service from second-degree misdemeanor assault to a second-degree felony assault. And, you know, it's not an exaggeration what's been said here today that the women and men who operate transit service are heroes. During this COVID-19 pandemic, they've shown up to work every single day to provide our region with a critical service. They get riders to their doctor's appointments, to the grocery store, frontline jobs at hospitals and at medical facilities. And without them, the region would absolutely stop moving. We owe every single one of our light rail, metro, bus, MARC, mobility operators a great deal of gratitude. And these extraordinary men and women provide exceptional service to the residents of Maryland every day. And unfortunately, much of our service area is located in one of the most violent regions in the nation. And I'm sad to report that despite the good work of our MTA police force, since 2013, an average of 50 assaults against MTA operators have been reported each year. You may remember, and as President McMillan noted, MTA lost a very beloved member of our family just this past October. Marcus Parks was a 20-year veteran bus operator, graduate of Lake Clifton High School. He was tragically shot and killed in downtown Baltimore in the line of duty. Marcus was a committed public servant who was dedicated to improving the lives of those that he served. And he's no longer with us because of a senseless, inexcusable act of violence. And this should not be the case. And so it's for Marcus and for the safety of all of our operators that I absolutely feel compelled to be with you here today. It's my belief that Senate Bill 91 will be a strong deterrent against this type of unconscionable violence, and the time to act is now. So please, let's not wait another moment before taking action to protect these frontline heroes. It's for this reason that I'd like to ask the committee for a favorable vote on Senate Bill 91. Thank you.
Thank you, Mr. McMillan. And with your testimony, that concludes the panel, or the rounds of the panel. I don't see any hands raised. We do actually have one. So Senator Sidnor, here you go.
Thank you very much. Just looking at the language on for line 10 and 11, I want to make certain that I understand what is encompassed in with engaged in providing public transportation services. And I asked this question, my mother used to work for MTA. She was an MTA bus driver, and I can recall during one of her routes, I think it was a snowy day, and I think for whatever reason, she was adjusting her mirror so that it had ice and things on it. And out of nowhere, she was struck in the face with an ice ball. Now, obviously that instance is different than if she was assaulted during the course of driving, and I can think of what had happened maybe within the past year or two, I think over in Asia, where a bus driver was assaulted and a bus ended up going off of a bridge, killing everyone that was on that bus. So again, what I'm wondering is when we're talking about engaged in providing public transportation services, are we talking about essentially once a person puts on that uniform, they're engaged in providing public transportation services? Or are we talking about the more narrow focus when they're actually driving the bus and their assault could not only endanger their lives, but endanger the lives of the passengers?
Senator Sidnor, was that a question to the Vice Chair or to Mr. McNutt?
You know, sure, Vice Chair, or even I'd be curious to think what may be on the minds of some of our members of the ATU as well.
I'll take the first crack at it. And so I'm going to look over here at the language. If you look at the language, it comes from the language immediately above it. So where it refers to, so lines 6 through 8, where it's referring to firefighters and EMS workers, it's just pulling that engaged in providing emergency medical care or rescue services. And so I'm not sure we can imagine every factual situation, but I don't think it is as limited as a transit vehicle in operation, in other words, moving. I think it anticipates something less strict than that, but neither do I think it's so loose as to be anytime someone is in uniform, they are engaged in public transit operations. So I know that doesn't provide the specificity you're looking for. I don't think we can anticipate every fact situation, but I think using language that we've already had in statute probably encompasses the behavior we're looking to encompass.
Might I add that too, when I read the language as far as interpretation of that, I was thinking more so along the lines as well that it was giving protection to maybe the mechanics. Like, you know, a bus can break down in any neighborhood. And when a person sees a mechanic come out, put a little pressure on and say, oh, is this bus going to be in service? The mechanic may say, oh, no, it's out. And then the person may just be angry at them and towards some and make some towards aggression towards them. And I was thinking that this bill will probably also give protection towards them as well, and not just operators.
Okay, yeah, any other individual, okay, thank you.
Mr. Neighbors, do you want to chime in?
Yes, you know, all too often, usually the bus doesn't break down in the best of location. We've had occasions where 2 or 3 guys were route through the tow truck. Tow truck's about 36 foot long. So if you're on one side and you always travel with a backup, if you're on one side and you're both are hooking the bus up, the people tend to go through the toolbox, take whatever it is available, not only harassing the operators on the mechanics on the street, they go as far as even climbing into the truck. The truck has to remain running to operate all.
And Mr. The feed is going down a little bit.
Hydraulics. So it's all encompassing. I'm sorry, did you hear any of what I said?
We heard most of it, then your feed started going out a little bit, so I muted it because you were
okay. I'm sorry. Well, you know, if you think a bus weighing 30,000 pounds, 40 foot long is dangerous. If they drag it off, steal a truck, a 36-foot truck, dragging a 40-foot bus with a combination of more than 70,000 pounds, possibly not knowing the characteristics or how to operate this tow truck, you have a real problem on your hand, not only for the transit people, but the public at hand. And you know, it goes back to just motion while the driver's distracted and keeping his eye on this road. So with that, you know, now you got this 40-foot vehicle, 30,000 pounds, traveling down the road with other vehicles. And with these assaults happening, if the operator tries to leave the seat of the bus for self-preservation, it's an automatic termination. Thank you.
Thank you. All right. Seeing no further questions, that will conclude the testimony and the hearing for Senate Bill 91. So we'll now move on. Thank you all very much for your time. We'll now move on to Vice Chair Waldstreicher. We'll have Senate Bill 143. So Vice Chair, the floor is yours.
Thank you, Mr. Chairman, members of the committee. As everyone knows, we are now in a racial reckoning when it comes to criminal justice. And we know something now that was once controversial, but is no longer controversial. And that is that our marijuana laws have a disproportionate impact on people of color. Many of us believe that the solution here is to fully legalize personal amounts of cannabis, but standing up an entirely new industry during a session over Zoom is unlikely. And so we need a bridge that takes us from where we are now to the possibility of full legalization. We need a bridge policy that is simple, non-controversial, and meets the moment of our racial reckoning. This bill does just that. It raises the decriminalized personal use amount from 10 grams to 1 ounce. This would put us in the mainstream of our sister states. A majority of states have decriminalized small amounts of marijuana. red states and blue states, Republican states, and Democratic states. And of those states, Maryland has the smallest amount of decriminalized cannabis in the entire nation. Most have 1 ounce, which is what this bill does. Some have even more. Versions of this bill have passed both the House and the Senate. It's the right thing to do to meet the moment, and it's a simple and elegant way to achieve it. Mr. Chairman, members of the committee, I ask for a favorable report on Senate Bill 143.
All right, thank you, Mr. Vice Chair, and thank you for bringing forward this piece of legislation. We'll first go to questions for the sponsor, and I see that we have Senator Casserly.
Thank you, Mr. Chairman. So lay out my understanding of the facts so that you can disagree with those if I'm in error. But in previous sessions dealing with the current limit, we were told that the current limit would be like roughly 20 marijuana cigarettes. This is like 3 times that. So it would, I'm estimating this would probably be like 30 marijuana cigarettes. Does that sound about right to you? You there?
There we go. Yes, 3 times. Okay. 1 ounce is about 3 times 10 grams.
Okay. And so I just description from witnesses the last time we had this issue came up, and they estimated it would be like 20 marijuana cigarettes. I know that the State Attorneys Association attached to their opposition letter a photograph of I guess a container of roughly 1 ounce. So is there an intent here to support? I mean, how would you distinguish between at that quantity? How do we distinguish between allowing possession of small amounts, basically legalizing possession of small amounts, versus legalizing sale and distribution? Because at that quantity, I would just expect that people, if you're doing for your personal use, you're not walking around with 30 marijuana cigarettes. If it's just for your personal use, that would indicate an intent for sale and distribution. So is the intent here to go ahead and legalize sale and distribution?
It is not. It is emphatically not. So the sale and distribution remains illegal under this bill. This bill doesn't change that. The bill also doesn't prevent our prosecutors from charging possession with the intent to distribute, as long as there is other evidence around that intent was real. So scales or other paraphernalia, baggies and the like, that would indicate the amount is not for personal use. But simply walking around selling it, I mean, in order to prosecute, you couldn't get the person for, you'd have to wait till a transaction was completed. You couldn't have arrested them because you saw a handgun on them or something. You would have to actually get them selling the marijuana in order to get them on a distribution charge, right? Well, I'll leave it to the prosecutors to describe some of the factual situations. I would imagine if someone is walking around on a street corner with a firearm, that would be sufficient evidence to indicate a possession with the intent to distribute. This is where there is no such evidence. A person in their home with a personal amount, no weapons, no street corner, no scales, no baggies.
Well, I think we already determined yesterday that it's okay for those guys to be packing heat. I think that was the bill yesterday, so that wouldn't do it for us. Okay, I read the prosecution's opposition and some of the others, and it did seem troubling to me that, and when this bill first came up, the intent was that people pulled over in their cars and they're arrested because they have a single marijuana cigarette or 4 or 5 or a small bag of marijuana, would then be arrested and prosecuted. And we were trying to avoid all of that. And so we just said, taking that off the table, you know, that we're just decriminalizing that to civil offense. But now we're, you know, you're going around with 30 marijuana cigarettes, and what seems like an awful large amount for someone to just sort of casually carry around. And obviously, I mean, what else are they doing carrying around that volume other than engaging in the transaction? And does that really make sense that we're going to turn a blind eye to that and treat it as though they simply were in the park behind the you know, sitting on the edge of the bank of the stream, smoking a single marijuana cigarette versus driving in their car and whatever. Okay.
I think,
Thanks for-
yeah, you and I, Senator Cassidy, I think feel the same way about drug dealers. And I'm a father, and my kids are about to be teenagers, and so in no way does this condone the dealing of drugs. If I thought it did, I wouldn't introduce it. And
just more of a, you know, don't believe your lying eyes kind of person. I'm sort of one of those folks who says, look, let's not have the law ignore what's right in front of them. I mean, if a police officer has some justifiable reason to stop you and search you and find 30 marijuana cigarettes, why should we go through the farce and pretend that you are not heading out to sell marijuana? You were either then in the process or you're going to head out to be the process. Why should we engage in the farcical assumption that, oh no, this guy just really has an itch for constant marijuana consumption? So we've already gone to the extra step of saying you can get a medical marijuana card. You can go to a licensed distributor and get it. So you did all that. And if you're coming from the distributor, you would just simply show your card. I just got this from the distributor. So this is somebody who for whatever reason couldn't qualify for that card, didn't go get it there, but they're walking around with this much of a volume. And it just seems like we're going to engage in a fallacy here. And I don't know why we would want to do that, right? Either legalize it or don't legalize it, but let's be honest with ourselves. So, okay, thank you.
All right, thank you, Senator Castley. I think I saw a question from Senator Huff. Do you still have a question? Are you good? Okay. Any other questions for the sponsor? Okay, great. We'll now move on to the panel. Ms. Manuel, Janet, you're next.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Yanetta Manuel, and I'm here on behalf of the ACLU of Maryland in support of SB 143. As you all are aware, there are massive racial disparities in our criminal legal system. Despite comparable rates of use, marijuana possession arrests disproportionately affect communities of color. In 2013, Baltimore was 64% African American, but 91% of all marijuana arrests were of African Americans. In 2010, Montgomery County was only 18% African American, but 46% of all marijuana arrests. Although the Maryland General Assembly has taken steps to reverse some of the harmful effects of the war on drugs, there's still more work to do. After passing legislation to decriminalize possession of small amounts of marijuana, there has actually been an uptick, more pronounced in some jurisdictions, in marijuana distribution arrests since 2014. According to the 2015 Uniform Crime Report, as compared to 2014, arrests for possession of marijuana decreased 37%, while marijuana distribution arrests increased 5%. In Montgomery County, there were 328 arrests for marijuana distribution in 2015, compared to just 83 arrests for marijuana distribution prior to decriminalization. This trend suggests that at least some portion of persons in possession of 10 grams or less are now being charged with a distribution offense, when the offense may in fact be appropriately charged as possession. And since 2016, the Uniform Crime Report shows that arrests for marijuana possession begins to increase again, especially in places like Montgomery County, which had 5,135 arrests for marijuana possession in 2017, while Baltimore City had 563. And of the 26 states that have decriminalized marijuana, like Senator Waldstreicher mentioned, Maryland's 10 grams is the smallest amount decriminalized, next to Hawaii, which has legalized 3 grams. The majority of states have decriminalized at least an ounce, with several having higher amounts. I also want to share that we learned from data we received from the courts that between 2018 and 2019 in Baltimore County, there were 1,314 people charged with possession of marijuana over 10 grams. And of that 1,314 people, 80% were Black, despite Black people only making up 30% of the county's population. A conviction for possession of over 10 grams still carries a maximum incarceration penalty for 6 months and a maximum fine of $1,000. And even if these charges do not result in guilty convictions, there is still a bunch of negative collateral consequences associated with being charged, especially with the unit rule, as this committee is familiar with. We believe that increasing the legal amount to 1 ounce and setting a threshold of that possession of 1 ounce or less of marijuana alone cannot be considered possession with intent to distribute, can potentially divert some distribution charges, reduce the incarcerated population, conserve judicial resources, save taxpayer dollars, and avoid the disruption of lives caused by unnecessary entanglement in the criminal legal system, which is even more critical now that we are in a global pandemic and our prisons and jails are amplifiers of infectious disease such as the coronavirus. More importantly, raising the civil possession amount has the potential to reduce the negative collateral consequences of criminal convictions, including loss of wages, employment consequences, and household instability. And lastly, I would just like to address some of the opposition's testimony. They will say that marijuana is a gateway drug, but the theory falls victim to assumption that correlation alone suggests causation. And in fact, research does show that marijuana can actually serve as an exit drug, helping people fight withdrawal symptoms of opioids and alcohol. They also say that increasing the legal amount will increase youth use, which is simply not supported by research. In fact, in Colorado, they saw a statistically significant decrease in youth use. We know that for a fact that eventually we will be moving towards legalization. So it's critical that we take the necessary steps to minimize racial disparities and stop punishing people for the drug that we're getting ready to capitalize off. And lastly, this bill already passed this committee in the Senate in 2018 when Senator Zirkin introduced it, and it already passed the House last session. So for all the reasons, we urge a favorable report on SB 143.
All right, thank you, Ms. Manuel. I will now move on to Mr. McAllister. Gordon, you're there. We can see, you can unmute yourself. Your camera's not on, but we can still hear your audio view. There you go. The floor is yours. Mr. McAllister, can you hear us? All right, while we get that sorted out, we'll move on to Mr. Frazier.
Good afternoon. I'd like to thank the chair and the vice chair for having me today. I'm Stanford Frazier with the Public Defender's Office, speaking in favorably of Senate Bill 143, and we urge the committee to have a favorable report. I'd just like to note that as of 2020, 57% of Marylanders supported marijuana legalization, with only 38% opposed. Recent polling from Gallup shows that nationally, 68% of Americans support marijuana legalization. And while this bill is in full legalization, we believe it gets Maryland in the positive direction when it comes to its marijuana laws. Speaking to the vice chairman's point, as a public defender in Prince George's County, I have plenty of clients that possibly work in Prince George's County, but live in DC, or vice versa, live in Prince George's County and work in DC, where up to 1 ounce is decriminalized. So they go from one jurisdiction where they may work, coming back home, and then they now have what is considered a criminal amount of marijuana. If you look at some other peer states, up to 1 ounce is decriminalized in Delaware, as well as in Virginia. Additionally, Virginia went even farther in 2020 by passing a bill that prevented law enforcement from using the odor of cannabis as a pretext for searching and seizing property. And that will actually go in effect March 1st, 2020, but that was passed last year. There's also reports that Virginia, another peer state, is planning to legalize marijuana this session. As a public defender, I'd also want to note that some other evidence of distribution that commonly is brought forth by the prosecution are individual baggies. They execute search warrants to search a house or property. You can execute search warrants on a phone to see if there's communications about buying from a large supplier or selling marijuana to individuals. So there's evidence that prosecutors can present besides the amount of marijuana if they need to prove possession with the intent to distribute. For all those reasons, we ask for a favorable report.
Thank you very much, Mr. Stanford. And now I see that Mr. McAllister is back up here. So Mr. McAllister, you are up next. You've been unmuted, but we can't hear you. Is there anything you do to adjust your microphone? All right. While I'll have someone chat you, and we'll get in contact with you, see if we can fix your technical problems. But just a matter of expediency, we'll keep it going here. So now we'll switch over to the opposition panel. And that is Mr. Schellenberger. You are up next.
Can you hear me?
We can, yes.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. Good to see you all this time. I appreciate Mr. Senator Casserly bringing up my written testimony. I hope you please take a look at it. It is not only on behalf of myself, but it's on behalf of the Maryland State Attorneys Association. And attached to that testimony is a picture of slightly more than 1 ounce of marijuana. I think all of us can agree that that amount of marijuana certainly, hopefully, would not be consumed by one person in one day. In fact, my folks have told me that the current law of 10 grams, making it a civil offense, would allow an individual to possibly roll 10 to 15 joints. I would argue that 10 to 15 joints is a pretty good amount of marijuana. Again, I hope 10 to 15 would get you through more than a day. Certainly, if we went up to an ounce, we're now talking about 28 to possibly 30 or 40 joints. Again, it's a considerable amount of marijuana. Not only do we have the civil law, 10 grams or less, but every state's attorney's office in the state, when we're talking about simple possession, including mine, we have a marijuana diversion program. And that is, you come in on your first possession. That means now you have more than 10 grams, your first possession of marijuana, and it's more than 10 grams, we offer you diversion, which is basically doing some community service in Baltimore County for 2 Saturdays. So we not only have the civil amount, we have diversion that's offered all over the state, and then we have possession that often does not get charged. Now, I will tell you that the way the statute is written now, particularly with the presumption at the end of the statute, it creates a presumption that if it's an ounce or less, then there's a presumption against a prosecutor that it's not possession with intent. Well, what about the example that you have slightly less than an ounce, but they are in small baggies in a car sitting on a street corner? You know, that under the presumption, I would have to rebut and try and prove that you had an intent to distribute. And with all due respect to Vice Chair Waldstreicher, I do not believe I could win a case in front of a judge. If I had that amount of marijuana, that is an ounce, and a firearm. I think I need more. I think I need baggies. I think I need a scale. I think I need more indicia. So based upon all of that, I believe that I'm asking for not to pass this bill. And finally, I remember the legislature last summer had a huge study going on, and I never really heard the results of that. I remember testifying in front of that group and did not know if they came out with a final report. Thank you very much for your time. Sorry I went over.
Thank you very much. We're going to go back to Mr. McAllister one last time, although I see he's vacated his seat. So we will just refer to his written testimony during the voting session. I do see a question from Senator Huff. So Senator Huff.
Yeah, thank you. I have a question for Scott. So I'm trying to navigate this. So in the past, we've done a version of this has passed out of the committee, actually like 2 or 3 years in a row. We did it where we took and we decriminalized up to an ounce, but then we added an amendment. And I believe the amendment, I was just double checking, was making it illegal to have marijuana in the passenger seat. So we were trying to clamp down on people who were driving and smoking marijuana, because obviously there was this loophole where you could just hand the joint over to your buddy in the passenger seat. At least that's what it was at the time. So I guess what I'm looking for, my question is dealing with marijuana law. And I know in the past we've discussed about smoking in public and people walking around, outside an Orioles game or whatever, around everybody smoking marijuana. It seems to me we've already sort of crossed the Rubicon as far as the decriminalizing. So now we're debating over the amount. But what is lacking? I guess what gives me concern is there seems to be some lacking as far as smoking in public or in the car. Maybe could you give us some insight on where some of those our guidelines are not clear or completely lacking?
Thank you, Senator Huff. If you recall, I have been arguing and testifying that smoking in a car should be illegal for several years. And you may remember that picture that I brought down where one of my prosecutors was dressed up, drinking a beer, which is illegal behind the wheel of a car. But if you only have less than 10 grams, it's not illegal just to smoke. Now, I could maybe prove that you were under the influence, but that's a whole lot of different factors that go into effect. So yes, I agree. If we're going to do this and go up to an ounce, which I think is a lot, we at least need to talk in terms of not having it in the car, because you're right. You can hand it to the front passenger, hand it to the back passenger, and now suddenly it's going to be more difficult for me to prove that you might be under the influence. The other one is smoking in public. I do have someone I know who was out in Colorado at some point, and they just said that the odor was everywhere. I mean, you just really noticed it. And that might not bother some people, but it might bother other people. And so, that's certainly some consideration that I think we have to talk in terms of. And those were the conversations that we were having when the legislature were having those hearings in joint committees. Shouldn't be joint committees, but they were joint committees in which we were talking about these issues, smoking in public, smoking in a vehicle, and what amounts, where do you draw the line? And I just keep coming back to, this is a lot more than 10 grams. So that's kind of where I am.
So what is the current law right now with respects to driving while with marijuana in the car? What is the current, where do we stand?
Well, it gets very difficult because the Court of Appeals has been dealing with some Fourth Amendment cases about the fact that now less than 10 grams is civil, and whether that would give them a right to search. And so you get into the Carroll doctrine. There was a recent case in which, they touched somebody, but it was a small item. So therefore, if it were like a joint or maybe a pipe, it might not have been against the law, and therefore it would have been civil. So we're still kind of working our way through all of these cases. But that becomes another problem. Would the odor of marijuana when you pull over a driver be enough to allow a search of the car? And then even if you search the car and you find this, you're now talking about a civil citation. In addition to maybe being a drug recognition expert into the scene to do a test to see if the individual is under the influence. So it creates a whole lot of problems when we start talking about cars and vehicles.
And as far as smoking marijuana in public, I guess there's no. I mean, look. If you go to a music concert, probably for the last 40 years in this country, you have the smell of marijuana, but you don't expect that if you're walking by. I don't know. You're walking by a school or something like that. So what is the law right now with as far as smoking in public? Is there any guidelines whatsoever?
No.
Yeah,
so, I mean, the question would be, if you're sitting in the park and Senator Huff goes there with his family and wants to have a picnic and somebody's right next to him with just, less than 10 grams, I think, I don't know what would stop him. I mean, you could give him a civil citation, but now we're going to go up to this and and hand him a ticket.
Yeah.
And so I think that's problematic.
It's a little different. Somebody shows up with an ounce of marijuana in the park. So, all right, a lot of interesting things to think through. All right.
All right, thank you both very much. Any further questions from the committee?
Thank you so much.
All right, seeing none, that concludes the hearing for Senate Bill 143. All right, we'll now move on to Senate Bill 220, which is Senator Hettleman. Senator Hettleman, you have the floor.
Thank you very much, Mr. Chairman. And I'm having a little bit of Wi-Fi instability, so if I disappear, I'll be right back. hopefully. Okay. Thank you very much. I'm Shelley Heddleman, Senator from District 11 in Baltimore County, and I'm here in support of Senate Bill 220. This is a bill that the committee saw a version of last year and passed, and actually the Senate passed last year. It is a bill that we've changed it somewhat. So I want to walk through those changes, and the committee members were sent an amendment that we have drafted for your consideration as well. The bill, the amended bill, would do a number of important things. First of all, as we, I think, have seen in this committee and certainly read in the newspapers, hate crimes are on the rise and have been over the last decade. They've been, they range in order of seriousness. They range from spray painting of a swastika to the hanging of a noose to the horrible, horrible murder a few years ago of Lieutenant Richard Collins in College Park. And this obviously is is horrible for the victims, and it also is terrorizing for larger communities. We have penalties on the books, and our society has said that there are certain crimes, because they're motivated by particular bias or hate towards groups, that they warrant extra penalties. And those punitive responses are appropriate. But what this bill does, it does not heap onto those responses. What it does is try to rehabilitate and address some of the underlying root causes of some of these hate crimes. Many people who are engaged in hate crimes are not sort of part of militias or larger groups. Some of them are youth. What we know from research is that many of them are young males between the ages of 16 and 25. And they could benefit from instruction and from education. And these rehabilitative and restorative approaches have been used in other communities and in other countries, and they've seen positive results. So what this bill would do would give judges the option of demanding that someone who's convicted of a hate crime participate in an educational program. And this educational program would be created under the auspices of the University System of Maryland. And we've talked with them, and they helped to craft some of these amendments. And the Administrative Office of the Courts and the Commission on Civil Rights would work with the offender to make sure that they underwent the program. The other important thing that this bill does is it adds gender-related identity to the hate crime statute. And we've changed the definition as it was originally introduced to be consistent with that terminology in other parts of the law. So that's what the bill would do. And we just think it is a very important restorative approach to provide to judges, and could have a very positive effect on preventing people from recidivating, as it has in other communities where these kinds of programs have been instituted. So I'm happy to answer questions or turn it over to my panel. Thank you very much.
Sure. Thank you, Senator Heddleman. And Senator Castley has a question for you.
I just have a brief question because I'm looking at the fiscal note. You talked about hate crimes being on the rise and stuff, and it looks like it's been pretty consistent, at least for the past 2 years, that we're not, I mean, we're talking 20 violations in 19 on 304, 4 on 305, and 2 on 305-2. And then for 20, it's actually down a little bit under 304 and 305-1, and up slightly, I'm sorry, down on 305-2. So is there something else I'm missing that because you did make the statement that this is sort of taken off?
I have data on over the past 10 years, and also some of my experts on the panel can address those issues.
Okay, I'm just not seeing it in here. Thank you.
If you click through on my testimony, there is a, I don't know if it transferred, but there is a live link that you can click through to other data.
All right, thanks.
Fantastic. Okay, thank you, Senator Heddleman. Seeing no further questions for the sponsor. Oh, we do have one. Senator Huff.
Yeah, I'm trying to figure out, I mean, today's been our day of bills with special penalties for assaults for all kinds of different groups. And just to be honest, we had I didn't ask questions, but we had the maintenance workers, we had, or the bus drivers, we had the sports officials. And I generally don't like doing special carve outs. Maryland already has, it's a 10-year misdemeanor. I think we're the toughest in the country when it comes to assaults now, but a hate crime is a felony, correct?
That's my understanding.
Yeah, so I mean, this is really tough. So you not only get the 10-year that Maryland has, but you get felony on top of it. So I like to make sure, and the problem is too, I mean, you see it, today was a perfect example of what's wrong with Maryland's assault laws in that we have already 4 different groups in that want to be added in. It just never ends. So that's why it's good to have universal laws. You assault, but aside from that, we've already have hate crime. So we've done that. So the question though I have is, do we have, in this case, gender expression, gender identity? Do we have numbers as far as the justification of why we need to do this?
I am going to have one of the people on my panel speak to exactly that point. Jeremy Lemaster from Free State Justice can specifically speak to the numbers of hate crimes against people who are transgender.
Okay, because I like to know numbers. To be honest, I had, and I'm really seeing, it's not about your bill. I could have said this on the 3 other ones. It's just, this is the 3rd one we've had of adding different people for assault, but we had, we did this for firefighter years ago, and I really have heartburn that we did that because I don't know that there was examples of it then on that one, making what we did the enhanced penalty. So we've just done this constantly. We've had these enhanced penalties for different groups, but separate of hate crime. So, but I do want to know if there's ones for that. Secondly, as far as the education component, I mean, can't a judge already order that as part of a sentence? Don't we give judges latitude? I mean, quite frankly, if you commit a crime, it's a felony. If somebody did something that's a felony, they can sit in prison and read a book for 10 years about it for all I care. It's the punishment that is a part that the law cares about. But the judge can already order, can't they order?
Sure. So the judge certainly has the freedom, but there is no already established curriculum to address these issues. And what this bill does is it shines a light on these kinds of crimes, and it would mandate the creation of a curriculum that would talk about bias and talk about kind of the deep-seated issues behind the actual crime. So it does, a judge could, but they have actually nothing to really direct an offender to right now. And this bill mandates the creation of a program and gives them the tools to be able to do it in a more targeted, comprehensive, thoughtful way.
Do we do this for anything else? I mean, we deal with child molesters and sexual predators, all kinds of human traffickers. Do we have an education curriculum for any other crime in Maryland?
I cannot speak to that. I don't know.
It just strikes me as, I see with a number of these bills that once we pass it and do it on this bill, we're going to get 10 bills next year with curriculums on all these other crimes, which are all terrible. That's why they're felonies and these people should be in prison. They should be punished. So, all right, I'll look for the testimony.
Well, again, I would say that there are some hate crimes that are misdemeanors. And so for the less violent ones that this
what hate crime is a misdemeanor?
I think a swastika spray painted on the side of a school.
No, maybe I'm wrong, but I thought hate crimes, maybe it says the assault portion is a felony, and then I thought we made all hate crimes felonies though, but maybe I'm wrong.
My understanding is that they range from, up to 3 years in prison for a misdemeanor or $5,000 fine to up to 20 years in prison if the crime results in death. So I think there's a range.
Yeah, I see it right here. In general, so it's a separate misdemeanor right now. So it's a misdemeanor right now, but it's separate on top of it. So if you paint a swastika, there's a crime of just vandalizing, destruction of property, which you normally would get. But on top of that, we add another 3,
right?
Because it's a big crime. And then it's the felony 10 years. That must be for the assault if it's an assault.
Right. So I hear what you're saying, certainly if there is a murder involved, but if you're talking about, kids who are doing some things who, kind of playing around in this area, then I do think that this could be a very effective tool for a judge to mandate their participation and could, head off more serious crimes down the road.
But you don't mandate it, do you? Because the judges aren't going to want to mandate it.
No, but the judge, what I'm saying is the judge mandates it. No, we do not mandate what judges do.
I just question the effectiveness of doing that, because so we're going to say in the law that a judge can do this curriculum, but the judge already in the law now can do the curriculum. So
But
why not just have the group that writes the curriculum write a letter to the judiciary and say, we've got this curriculum you can mandate, versus us passing a law? Because then next year, I mean, not to sound annoyed, but we've had 4 bills in a row about these special crimes and penalties, and like, if we're going to do these, people need to start giving us numbers about why we need to create new penalties for different groups, maintenance workers and bus drivers and everything else. So I look forward to hearing the numbers of why we need to include this group in. Because look, you assault any citizen in Maryland, you should get a penalty. You do. We punish you. There is no state in the country harder for an assault, for example, than the state of Maryland. Nobody.
With all due respect, we've already gone down that road. We have hate crimes on our in our
Yeah, we've added 3 groups to the assault law. Now we had 3 other groups come in today, and we probably got 10 other groups the rest of the session on it. So, all right, thanks.
I did have some questions for you to put my mind at rest. So if you could
I can hear someone's feed coming through. There we go. Okay.
Thank you very much.
You will hear that? Okay. I don't know what that was, but we'll now move on. Any further questions for the sponsor of the bill? Okay, seeing no further questions. Thank you, Senator Hedelman. We'll now move on. I see that State's Attorney Braveboy cannot make it here today. She sends her regrets, but refer to her written testimony. And so we will now go to Ms. Chaudhry. Zainab, you are up next.
Okay, there we go. Can you hear me now? Great. Good afternoon. Thank you so much for this opportunity to testify before you, Honorable Senator William Smith and members of the Senate Judicial Proceedings Committee. On behalf of CARE, the Council on American Islamic Relations, I thank you for this opportunity to testify in support of Senate Bill 220 entitled Hate Crimes, Protected Groups and Penalties, sponsored by Senator Shelley Hedelman. CARE is America's largest Muslim civil rights and advocacy organization. Our mission is to enhance the understanding of Islam, protect civil rights, promote justice, and empower American Muslims. And as the senator mentioned earlier, hate crimes have actually reached an all-time high in over a decade. In fact, there was a report by AP that indicated that there were 7,314 hate crimes last year, up from 7,120 the year before. And so we're seeing a steady uptick in the number of crimes that are being reported. This means that there are significantly more victims and survivors of criminal offenses due to their race, religion, ethnicity, age, and gender than there were over 10 years ago. Hate crimes are a malignant outgrowth of prejudicial thoughts and beliefs which have no place in today's society. Unlike other violent crimes, hate crimes are often motivated by ignorant, misguided beliefs about a particular group of people, as I'm sure many of us can relate. Anti-bias education, we strongly believe, helps to create an awareness of human differences. It promotes diversity, it improves relationships, and teaches the harmful consequences of hate and bias. Such a training will help reduce the prevalence of these types of crimes, we believe, by addressing the prejudicial thoughts that are underlying that fuel some of these incidents and the beliefs that fuel them. CARE supports this bill because it addresses a root cause instead of simply resorting to punitive measures. Yes, we could lock somebody away, but the fact that the underlying belief that contributes to this action would not be resolved is a big problem. We believe that these measures will help discourage hateful behavior in the future, and we respectfully urge your vote in favor of it. And as to the question about whether other crimes are also susceptible to this kind of education, I think that if not, then we should consider how we can change that, because unfortunately, ignorance does contribute to a lot of hate, and not just hate, but also bias in our community that manifests not only through hate crimes, but also bias motivated incidents. I thank you for this opportunity to testify and welcome any questions. And thank you again, Senator Hedelman, for your leadership on this issue.
Excellent. Thank you for your testimony. Next, Meredith. Hey, show over there. There you are. How are you?
All right, I'm here. How are you? Thank you, Mr. Chairman, and I don't actually see Mr. Vice Chair. He's off screen, and members of the committee. It's always a pleasure to be with Judiciary. Sorry, obviously we're not in person. For the record, I'm Meredith Weisel. I'm the Senior Associate Regional Director for the ADL, the Anti-Defamation League's DC office. You do have my written testimony. I want to highlight a few things from there, and then I want to actually answer a couple of the statistics questions to help with Senator Hedelman and explaining some of the things that she was talking about. So first, we fully support the bill, support the concept of hate crime offenders receiving anti-bias educational instructions that's related to the group or community by the hate crime offense. And we also support adding the gender-related identity to the law. Just for some background, ADL has been recognized as one of the leading resources on effective responses to violent bigotry. We also are one of the leading trainers of anti-bias education and bullying prevention programs for kindergarten through 12th grade. We also work on college campuses. So for over 3 decades, we've been providing different trainings on anti-bias education. The thing to remember is bias crimes are intended to intimidate not only the individual victim, but the victim's entire community. It leaves the family, it leaves the community feeling isolated and vulnerable. And failure to address this unique type of crime, including something like anti-bias education, can cause an isolated incident to explode into much more community-wide tension. So in light of the harm that it causes, it's vitally important to remember that the community most impact also has a say in this matter. And that is one of the things that can be working with the judge when the judge is considering different types of sentencing. So for a lot of those reasons, in some cases, they may wish to play a lead role in providing restorative justice programming and not just something like penalties, particularly when we're talking about misdemeanors, as Senator Hedelman was discussing. So for those reasons, we also think it's important and think it's even better than the bill last year that encourages and requires the Board of Regents to develop a curriculum for anti-bias, sorry, not the Board of Regents, to do anti-bias education on or before, I believe it was January 1st of 2023. It's important that this restorative justice programming for hate crime offenders does remain discretionary. It's essentially a tool in the toolbox for the judges. Now, as far as just some quick numbers on this, Senator, while you were asking some of the questions earlier, I'm going to look to my other screen just to my right. So just from a national level in 2019, the FBI hate crime statistics, race-based hate crimes were the most common type of hate crime. There was a 41% increase from 2018 to 2019 on hate crimes that were targeting individuals based on gender identity, which rose 18% then over the past few years. And just looking at some of the numbers in Maryland on what we call, ADL has, we call it a heat map, hate, extremism, anti-Semitism, and terrorism. From 2019 to the raw numbers, which we have not finalized of what we saw in 2020, it's gone from 78 to 191. So the numbers are increasing. So, and it's everything, not just from things that may be prosecuted as a hate crime, but also as bias incidents. And a lot of times the bias incidents are what we need to look at the restorative justice and look at the education training. ADL has, I'll just wrap up with this, something we call our pyramid of hate. Things start with stereotypes. They don't start with somebody being murdered. They don't start with somebody being assaulted. They start with things like swastikas or racial slurs, or other types of bigotry that we see just every day in the community. We don't see things like people storming Capitol Hill all of a sudden. This is things that build up, and it's so important that we have a tool like education to capture things, particularly that are under the misdemeanors. So with that, we urge this committee to give Senate Bill 220 a favorable report as you did last year. Thank you.
All right, thank you very much. And Jeremy, you're up next, so the floor is yours.
Great, thank you very much. Good afternoon, Mr. Chairman and committee members. And thank you for the opportunity to have Free State Justice here to speak in favor of Senate Bill 220. My name is Jeremy LeMaster. My pronouns are he and they, and I'm a Baltimore resident. I serve as the executive director of Free State Justice, a 30-year-old statewide organization that offers legal services and advocacy for low-income, lesbian, gay, bisexual, transgender, and queer Marylanders. Many of you heard in the committee yesterday, my colleague CP Huffman discussed the discrimination, harassment, and violence LGBTQ Marylanders experience at disproportionate rates. Just to reiterate, and this is part of my written testimony as well, Free State Justice's 2016 statewide needs assessment found that over half of our community members either experienced or knew someone that experienced harassment or violence in public spaces, with most individuals altering their daily routines out of safety. These findings were even more pronounced for trans and/or Black community members. Additionally, in the state, 20% of the reported hate crimes were related to sexual orientation and gender identity, the third most common after race and religion. To that effect, we strongly favor this bill's addition of gender identity and gender expression to this criminal code. We also appreciate some of the comments and questions raised by the committee. Just as some quick numbers, there are over 23,000 transgender Marylanders. And to this effect, we definitely support the addition of gender identity and gender expression to our hate crime legislation. Aside from that, we strongly favor this, the article that commissions an anti-bias education program for many of the reasons discussed. We feel that it embodies restorative justice practices and does not further advance carceral solutions. We hope that efforts and others like it can really prevent hate-based violence before it occurs. For marginalized communities, discrimination, harassment, and violence all germinate with the same root, bias. Before coming to Free State, I spent 5 years teaching on race, gender, and sexuality to undergraduate adult learners, utilizing anti-bias teaching tools. And we learned that bias is normal and healthy, and it helps our brain shortcut a bunch of information and it allows us to recall things very easily. But where we get into trouble is when we don't apply it, or when we do apply it uncritically to people. Adults can learn to monitor and counter bias, but not only tolerate, but value difference as well. And so with that, Senate Bill 220 could help create a Maryland that does foster inclusion through the valuing of difference. We urge a favorable report on Senate Bill 220. And again, thank you for the time today. I'm happy to answer additional questions on this bill.
All right, thank you very much. We have first, we'll go to Senator Huff, then we'll go to Senator Hedelman, Senator West, and then Senator Castley. So Senator Huff, you're up next.
All right, so I'm looking at the law now. So gender-related identity is already in the law now, correct?
Who are you asking? Would you like to address that question to? All right,
whoever wants to answer.
Panel, you can choose. Is it Jeremy?
No, it is not currently.
Maybe I'm wrong. So I'm looking at the bill.
Please look at the amendment. Sorry, the amendment goes to the gender identity. Do you have the amendment?
No, so I'm looking at the bill though. I mean, on the bill now, it has the current law. Page 2, line 13 of the current law brackets out gender-related identity, and it just changes it from gender-related identity or expression. So it looks like gender-related identity is already in the law.
Not in, if you look at the, we take out on page 2, let me see here.
Look at page 2, lines 12 and 13. Sexual orientation means the identification of an individual as to male, female, homosexuality, heterosexuality, bisexuality, or gender-related identity. It seems to be the current law.
Correct.
Okay, so that's not really at issue then in the bill, because correct. I see it adds or expression, but that's not really an issue. That's already the law.
Right.
So the next thing it adds or age.
We took that out. Sorry, we're getting rid of age.
You're getting rid of age. Okay, so gender-related identity is already the law. You're just adding or expression.
No, we're actually we're not using the term expression. We're referencing gender identity and saying it has the meaning stated in a different section of the code in the state government article, because for consistency.
And where is this? This is in your testimony?
This is in the amendment.
All right. Well, I'll have to look at it. I mean, I don't know where we did, but for intents and purposes, that's not a big change. Gender-related identity is in there. You're taking out age isn't in there. So the bill does what then? It just mandates this training?
It makes it explicit that gender identity is a hate crime.
But that's already the law.
Jeremy, where is Jeremy? It ties it back to the meaning in this other section and is explicit that it's covered. But
I can speak now. Yeah, so this is, Senator Hugh, thank you. This is essentially cleaning up the criminal code a bit to relate to where gender identity is already defined in Maryland code. And part of that identity or part of that definition includes a more robust description of what gender identity is, and gender expression is part of that. So we're not changing the criminal code here to really enhance or add anything. It's just more or less cleaning up the code to be more consistent where gender identity has been defined elsewhere.
All right. I mean, because to be honest, that's what my question is. If we're adding new things like age, or I thought we're adding gender identity, that's what I want to make sure justification. But gender identity is already in there, so that's a non-issue. That's already in the law. If you're removing age, then that's not an issue. So the only thing that really the bill does is this: the functional part is that this curriculum that we can suggest to the judiciary branch.
I want to respond to your question because you asked if there are any other parts of any other instances when we have given the judiciary an option for education. This is slightly different, but in 2019, we passed a law that authorized the court to order a defendant convicted of a charge of animal cruelty to participate in psychological counseling. So it's not exactly the same, but it provided another opportunity for a judge to do something that, of course, they may have had in their wheelhouse to do anyway.
They probably did. All right, thank you.
Senator Huff, actually, just to follow up on that, I mean, and this is for Jeremy, I guess. So I was checking with counsel on this as well. So if gender-related identity is subsumed and part of the definition of sexual orientation, you have then separated that out. And you've done that just for clarity and consistency type purposes, or there's no policy reason behind it apart from just.
Correct. I mean, I think it's gender and sexuality are complex. And so this is why we consistently are pointing to what we kind of consider a cleaner definition of what gender identity is, which is inclusive of gender expression. And so it's just, again, a way, like you said, just to really clean up the code and kind of tighten it up a bit and make it a little bit clearer and more consistent with where we're kind of talking and defining gender identity and sexual identity today.
Got it. Okay, so I mean, just and then you're not, in further clarifying the definition of gender-related identity, you add another qualifier or expression, and there are no real policy implications necessarily, just more, it's clarifying language, just to be clear. Okay, got it. Got it. Thank you very much. So now we have Senator Heddleman, you were next, and then we have Senator West and Senator Castley.
I said what I needed to say to
respond to
Senator Huff.
Okay, so Senator West.
Thank you, Mr. Chairman. I've been trying to find in the education article, section 12.120. I have not been able to find it. Unfortunately, I'm at home. I don't have the code in front of me, behind me in my shelf. So my question relates to, earlier today we had a hearing on a bill to require Humane Society officers to take up to 80 hours of initial training and then a certain number of hours annually. I can't find in this bill any limitation on the number of hours of one of these programs. Suppose a judge were to assign an offender to undergo educational training for the next 10 years. That would be too much. Don't you think it would make sense to put some sort of a limitation on the number of hours a person could be assigned to attend one of these programs?
Who would you like to direct that question toward?
I was looking at Senator Heddleman, but if somebody else wants to answer, that would be fine.
To be honest, I hadn't thought about that. But
I didn't either until we had that bill earlier today. And that was weighing on my mind, that we had a limitation on the number of hours.
I guess I have faith that judges will, be reasonable. But, if you wanted to put a cap in there, I'm happy to consider that.
Well, you're just near the bottom of the third page. You say an anti-bias education program developed and offered under section 12-120 of the education article. That's why I was trying to find it to see if that would have any kind of a time, an hour limitation on how long this program could last. So if it's in there, it's fine. I just couldn't find section 12-120. If not, I think we ought to put some limitation on how much education someone could be assigned to take, especially since they're going to pay for it.
I'm happy to talk about that with you further.
Okay, sure.
All right, thank you, Senator West. Senator Castley, did you still want to? There you go.
Thank you. So currently, the judge could impose on top of whatever sentence there was. I mean, assuming it was an assault, so you get the sentence for the assault, and then on top of that, the judge could impose up to 3 years in prison plus another $5,000 fine on top of the original offense. And now we're adding on this course. Is there any evidence that would suggest that the imprisonment and the fine either does or does not change people's behavior or biases? I mean, the person could have just gotten 5 years and $5,000 fine for the underlying offense and the bias issue. And now we're saying, well, we also want to add this onto it. Is there any indication that the additional time in prison and fine wouldn't satisfactorily change their mind? Or maybe there's evidence it doesn't change people's minds. I'm just curious the genesis of the additional request for additional. I mean, it is a penalty, so additional penalty.
So I think that there's no question that, you know, our judicial system exists for accountability purposes and for punishment purposes, but I would argue that there are many times where it doesn't really change hearts. An educational system can do that. And look, the other thing is I want to call it to your attention, and this is in my testimony, that this has been in effect in Germany and also in San Diego, and that they have had success with, again, people at the lower end of the scale in terms of the misdemeanors and youth that to which it was targeted. So I don't know that we're going to change, you know, hearts and minds of people who are convicted of murder and who are going to be in prison for many, many years, although I would argue that this would be beneficial to them as well. But I think part of the aim of this is to get some of the lower level offenders to really think and be immersed in the hazards and the dangers of and the effect on the larger community in addition to the victim directly. And, you know, this is a way to rehabilitate.
Thank you. And you refer to these other jurisdictions, and obviously I don't have any of that in front of us to look at it, but are they imposing the education programs instead of, or you lock them up and then send them to education?
Meredith, do you know the answer to that question? I don't know. I don't believe it's instead of.
So you would lock them up for their behavior and then you would pull them back out and try to educate them. I'm just, because the way it's written, it says in addition to. So the court would have to impose some kind of the court would have to impose, find you guilty on the misdemeanor, impose some imprisonment or fine, and then in addition to that, impose the education. And it just seems
right.
like
This is not instead of, correct. This is somebody is being convicted of a hate crime. This is in addition to.
Yeah.
Correct. And I apologize, I missed part of it. My internet went in and out, so I came in the middle. But there are other jurisdictions that have been looking at this, particularly since we've seen such an increase in bias incidents, not necessarily things that are always prosecuted as a hate crimes. And then, you know, looking at it from the perspective of the judge has another, and as I said before, another tool in the toolbox, because there still needs to be some sort of punishment, which is why on the lower level, you do have the misdemeanor that is there. Like as Senator Hedelman said, I don't think you're talking about somebody who has been convicted of murder, although that is certainly a possibility, and restorative justice has been known to be something that has really helped. I mean, if you look at our educational system, when we're talking about things like bullying and teaching kids just about bias.
But
There's
this is
no
under sort of
reason
justice,
why
this
this
is
can't
under sort
work.
of justice, because you've got to actually find them guilty, impose a sentence, and then this is an alternative. This is one more tool for the sentencing. For the
It is anti-bias, anti-bias education of any sort is something that gives an opportunity for people to confront what the crime was in particular and why they targeted somebody and why it was considered hate.
And then you referred to on the ADL side, you referred to, and it was 78 to increase from 78 to 100. And I didn't quite understand because we're over the internet. You talking about an increase in incidences. Can you, and I didn't catch what that was. What was that increase?
Sure. So ADL has what we call a heat map. It has hate. We track hate, anti-Semitism, hate, extremism, anti-Semitism, and terrorism. And from 2019 to our raw numbers, because 2020 just ended, but looking at the raw numbers in Maryland went from 78 incidents to 191 incidents. A lot of those are bias incidents, things like leafleting of propaganda, of vandalism, graffiti, incidents along those lines, not necessarily major terrorist attacks, things that would be considered at a misdemeanor level. So the numbers on that are still increasing. And what I was also talking about was the FBI hate crime statistics. And even though in general, Maryland actually went down slightly from 2018 to 2019. The raw numbers for 2020 are actually showing an uptick, and nationwide, we are still seeing the largest numbers that we've ever seen of not just bias.
So I just wanted to focus for a second on Maryland, because we keep drifting into national issues here. That's 78 to 100, but that includes just, I found a leaflet on the sidewalk, and it's a targeting people. It didn't. Do we have statistics specifically on a crime? I mean, I can, if I was disposed to, people can hand out nasty literature as long as they don't have to be nice to people. But as far as actual incidences that were classified for crimes under this statute, do we have numbers on that? Do you all have separate numbers on that for Maryland?
Yeah, I do not have that in front of me, but we could certainly pull up the hate crime numbers. I mean, for Maryland, it's also, you also have to take into account underreporting. So I think that's part of it. So you have numbers, but you also have underreporting, which is what we're finding. And also what is actually prosecuted.
To the web page, but it's kind of like really aggregated. It's hard to see what the numbers are, because it's like, here's the 5,000 page report on crime. Start digging. I was just wondering if somebody had these things sort of already parsed out, if there was a more targeted report, that so I don't have to like dig through all this and see.
Yeah, I mean, we could certainly send you follow-up of specific statistics on Maryland and looking at, what has been broken down as hate crimes. But just the point that I do want to make is that what actually can be prosecuted as a hate crime, and when a prosecution is looking forward, hate crimes charges don't always go through, even though something may be a hate crime, and you have to sort of keep that in mind and look at the trajectory.
Yeah, it's the same issue we have in all crimes, right? So yeah, it's the reporting. It's the best we got. Okay, thank you.
Okay, great. Jeremy, did you have something to say? Here we go.
Yeah, I was just going to point to Maryland State Police's 2017 hate bias report. For gender and sexual identity, there were at least 33 incidents of sort of verified hate crimes. So I just want to kind of give some of those hard numbers there of things that have actually progressed or been verified as hate crimes in the state. But wanted to echo what Meredith was saying and our needs assessment for the state, that as everyone's kind of hinted to, is a lot of challenges in not only reporting, distrust and working with or reporting these crimes to police officers in the first place, as well as challenges in sort of prosecuting these crimes as well. Don't necessarily speak to the incidence rate, but I just wanted to kind of do a follow up there and give you those numbers.
All right, fantastic. Thank you very much for that. Seeing no further questions, Senator Huff has a question. Hold on, let's see. Hold on. Go ahead and unmute yourself one more time. There you go.
I say I retract my request for data. So it's because we're not really changing anything. Now that age is out, so no, all the groups there, you don't need to send me any data. We already have sexual gender expression in the law. So I don't see there's a big change there. I guess the only question for me is the how we deal with the education part. But just for all those groups, you don't need to send me that data. I retract that request. Thank you.
Got it. Although it would be nice to have as context. All right.
I can send it. There, I have the State of Maryland 2019 hate bias report. We can send that around.
Thank you very much. All right, with that, thank you, Senator Hedelman. Thank you to the panel. And that concludes the hearing for Senate Bill 220. We'll now move on to Senate Bill 190. That's Senator Huff. Senator Huff, the floor is yours.
Well, thank you very much. And I will be brief. And I've got a bunch of kids that just finished school and I can hear them all upstairs. So Senate Bill 190, we've done this bill multiple times in the past. We passed it. In fact, we passed it unanimous last year. And this just deals with, in Maryland's public safety article, deals with marijuana. If you are a habitual user of any drug, you are prohibited from having a firearm. It's against Maryland's law. Well, this runs in clear contradiction with the fact that Maryland allows for medical marijuana. So the bill just simply says that if you are a medical marijuana user, that you are not breaking this law. I mean, under current law, a person who has a medical prescription for much more dangerous drugs like Oxycontin and other opioids, they don't have to face the prospect of losing their firearms. Since medical cannabis is legal in this state, it should not conflict with one's right to own a firearm. Critics may say this bill sets up potential conflict with existing federal law. However, the tension between state law and federal law is a basic concept of federalism. There are times when the states need to be more innovative than the federal government. Again, a patient in Maryland must not force between their lawful medical prescription and their lawful gun rights. For these reasons, I again urge the committee to give a favorable vote to Senate Bill 190. And that's all. We passed it numerous years, so it's the House that has not passed it in the past. This doesn't just cover the part of firearms. It doesn't give anyone new a firearm, anything like that. It just says you are not breaking Maryland's laws with respect to firearm if you're using medical marijuana. That's it.
Great. I've got another medical marijuana bill coming up, I think next week or so. So we should talk about, we'll do some work together. All right, seeing no questions. Thank you, Senator Huff. That concludes the hearing for Senate Bill 190. We'll now move on to our final bill of the day. Senator Kagan, there you are. How are you? I'll unmute you here. Hold on. So Senator Kagan, the floor is yours as soon as we can get you unmuted here.
There we go. I needed permission to unmute. Hello, Mr. Chairman, colleagues. Thank you very much. I would say best for last, but all the bills that you guys hear are so important. So thank you for your time. And I'm glad it's not midnight when we're hearing this bill. I'm Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville, and very proud to have spent the last 3 years as chair of the Next Generation 911 Commission. You all have heard some of these issues over the years. We've passed 9 bills, and Maryland is at the forefront of updating our 911 systems to Next Generation 911 in order to save lives. In August, Maryland, everywhere around the state, went live with text to 911. A lot of people still don't know that, so I'm just mentioning it here for you all and for anyone watching. On that day, anywhere in the state, you should always call, but if you can't call because you either are deaf or hard of hearing or have a speech impairment or having a health crisis or are in hiding, you can text to 911. Be sure to always include your location. Among the issues that we really still need to address is the issue of swatting, which brings us to today's bill. Before I start, I want to acknowledge my partners in all of this, including your colleague, our new friend, our new colleague and my friend, former Delegate Michael Jackson, Senator Jackson, along with Delegate Sue Krabs and Senator Ed Riley. We also have experts and telecom folks, 911 directors, and many other public safety experts that have been working on this legislation. You all should have gotten a copy. Rats, you're not going to be able to see it with my backdrop. You all should have gotten a copy of the third annual report mailed to you, and there are recommendations, including this one, included in it. There are three aspects of swatting that I'm going to talk about, and I have an all-star lineup on this panel to explain more. But bottom line is we're talking about jamming a 911 center. And as you've probably heard me say, when 911 fails, people die. I've had 3 people die in my district when 911 has not functioned the way it could or should, or that we all expect. One of those, Carl Henn, died when the 911 center was overwhelmed after a freak thunderstorm. So that was no one's fault, but sometimes there is malfeasance or problems that have to be addressed. The problem is that our penalties are way too light and people die. So there are 3 kinds, as I said, 3 ways of jamming our 911 centers that are addressed in this bill. One is called TDOS, and you should all have a glossary either in the commission report, or it was handed out to you, and or it's online. But TDOS is the telephone denial of service. So that would be someone calling, jamming the phone lines and preventing others from getting through. There was an incident where a kid set up tweeted a link, and when people clicked on the link, it automatically redialed their phone, and it shut down 911 centers in 12 states. There's DDoS, which is the digital denial of services, and that is through electronic means. So now that you can text to 911, it's a way of trying through other means to shut down access to a 911 center. Again, when people can't get through to 911, that means we can have the very best trained and equipped police, firefighters, and paramedics. But if they can't get dispatched because people don't know about it, because the phone system or the 911 center is jammed or shut down, that's a problem. And again, houses burn down, bad guys get away, or grandma dies from her heart attack. So the third aspect to this bill is called swatting. And that is when the SWAT team is summoned on false and sometimes racial or hate bias purposes. So there are stories around the country and even in Maryland where police have been summoned with inaccurate and malicious information. Hey, go to my next door neighbor's house. I think my Black neighbor has just shot his wife. And so police guns drawn, and sometimes it means that someone ends up dead, even though they're just sitting there watching TV. So I want to just flag a couple more things, and then I'm going to defer to my colleagues. In 2018, Baltimore's computer network that supported the 911 center was down for 17 hours. One of the 3 deaths in my district was when the system was down for less than an hour. So 17 hours, you can imagine the number of people who were affected. 19 columnist Leonard Pitts, an African-American journalist who was well known, was the victim of a swatting attack. So it's not just nationally hypothetical. It has happened here in Maryland. He was ordered to drop to his knees, handcuffed by police, and that the police had been notified, the 911 folks had been notified that he had just murdered his wife. So current law is basically too much of a slap on the wrist. We've got to make sure that there are serious consequences. So whether it's a teen thinking it's a cute joke, or whether it's an international actor or something, we've got to show that we mean a fine of up to $500 or a penalty of up to 3 years just isn't going to do it, in my opinion. So we are that if anyone attempts to disrupt, not even succeed, if they attempt to disrupt the service of a 911 center, we're proposing increasing from 3 years max to 5 years, and changing the $500 penalty to $25,000, up to $25,000. If they successfully 911 center, we think that the penalty should be even more severe, and it should be up to 10 years with a fine of up to $50,000. Swatting, current law, and that's again, SWAT team, where death or serious injury could result. So swatting right now, it's only up to 6 months, and again, a fine of up to $500. If law enforcement is dispatched to a scene, but if there is serious bodily injury as a result of police being dispatched, we're proposing that it be up to 5 years in prison and a fine of up to $25,000. I want to flag for you that there is a small amendment that was proposed and approved by the commission that just clarifies which type of services would be included and covered as technology is enhanced. We're not just talking about someone using a telephone, we're talking about laptops and watches and so many other devices. And so there are laws very similar to this in California, Connecticut, Indiana, Wisconsin, and probably elsewhere. But that's what I've got. I am happy to take questions. I really hope we moved this bill last year. We ran out of time. We did have this hearing last year. This is unanimously supported by the 911 Commission. And with that, if there are no questions, I'd like to toss it to Senator Jackson. Thank you, Mr. Chairman.
Thank you, Senator Kagan and Senator Jackson. The floor is yours.
Thank you, Mr. Chairman, Mr. Vice Chairman, and my partner on the Next Generation 911 Commission for the last 3 years. I think we've done some great work. I think the Commission has been very attentive to addressing concerns for our constituencies and including today and tomorrow's technology. The folks who will follow me will speak more specifically to that. For 32 years, I've been involved in the public safety arena. And I can tell you as an agency head and as a member of the agency prior to that, it's quite disconcerting when the resources, which are always limited in public service, are used or summoned upon for whether it's teenagers or someone trying to joke or someone trying to get back at a neighbor or whatever the cause may be. And when those resources get strained, it's a highly tense circumstance. And so there's always the challenge of ensuring, regardless of how highly trained folks in special units are, there is always an opportunity for something to go wrong, particularly where every citizen has a right to resist an unlawful arrest. And so if you send a unit to an address or an area, that is obviously that can end up pretty bad for everyone. So I am in full support of this piece of legislation, and we are certainly thankful to have Senator Riley as well as Delegate Krebs a part of our team, and we're asking for a favorable report. And I will also stand for questions at the end, Mr. Chairman, and I'll pass it on. Thank you.
Thank you very much, Senator. With that, we'll turn it over to the panel. We'll start off with Mr. Ferretti, Bill Ferretti. You are up next.
Thank you, Mr. Chairman, Senators. I appreciate being able to testify before the committee today in support of Senate Bill 101. My name is Bill Ferretti. As you learned, I am a former 911 director for Montgomery County, and I had the pleasure to serve on the Commission to Advance Next Generation 911 across Maryland with Senator Kagan as the chair. And I'd like to recognize Senator Jackson. Congratulations, Senator, on your move to the Senate. Senator Jackson served with me as I was the chair of the Cyber and Technology Subcommittee within the Commission for the first 2 years. As a 911 director and working in the 911 center, we experienced firsthand the impact of annoying and harassing phone calls and denial of service attacks on the center's ability to really effectively carry out our life-saving mission in service to the public. A 911 center is a unique target, unfortunately. Yes, annoying phone calls and denial of service attacks against a corporation, against an individual are annoying. They can be economically challenging and expensive, but the attack on the 911 center is compounded by the fact that when the 911 center is unable to complete its mission, its operators are tied up, its phone lines are tied up, its systems are taken down, then the person calling with a real medical emergency in real need of police assistance, reporting a large fire, none of those people are getting through. So that's why, is a tenet of this bill is saying, you know what, in those circumstances, we need more of a deterrent. And that's really, like a lot of laws, that's what we're looking for here, is a larger deterrent, not to go after the 911 center. When we look at, when I looked at Maryland Criminal Code a few years ago, when I started working on the commission, we saw that, the modern forms of communication, we're not just living in a voice world anymore, especially with the advent of next generation 911 coming into the 911 center. And as Senator Kagan talked about, we now have data, we have text, these other forms of communication. And again, those aren't just the 911 center, those are between, person A and person B within Maryland. And the annoying and phone calls, current statute really talks about phone calls in the context of voice. So first and foremost is the idea that we'll make sure that some definitions have been added, amended as part of the amendment by the commission in its latest amendment, so that just the misdemeanor itself is inclusive of voice, data, and text. Our cyber laws on the books also, which currently speak to data theft and intrusions, but again, really were looked at, I think, from reading them from a commercial perspective and not what it would look like and the impact it would have if you had an attack on a 911 center. So this legislation really, that's what the purpose of this is. The commission worked on this during its second year, and then again took it up in the third year of its time and in its reports. It would update the telephone misuse statutes to account for, as I said, text and data within, which are really now part of our telecommunication systems. As Senator Kagan mentioned, it really does take on the idea of swatting, this idea of providing this false information to a 911 center, using the 911 center as a tool illicitly in order to get this elevated police response to someone's home or business. And really, when you do that, you're creating a very potentially dangerous encounter between the public and your responding law enforcement officers. And I think in the divisive world that which we live in, those encounters are just further eroding public trust. So we really want to kind of find a way to deter that. And if people insist on doing it, well, then they should pay a higher penalty. So we seek to increase the penalty when they attack the 911 center to make that a felony. And the key is and I know when I testified before last year, the subject came up is, well, what if it's just an older person who's just calling, or a child? And really that's covered within the statute, because the statute talks about intent. There has to be intent here, an intent to interrupt or disrupt. So that puts the burden back on the government to prove that intent. So this isn't about going after the average person. Those are either going to be handled in a friendly manner or possibly at the misdemeanor level. But they're not. This is not designed to do that. Moving on to cyber attacks, which have unfortunately become all too common in our world. Public safety agencies and 911 centers have become targets. Senator Kagan threw out a couple of examples of those. I myself, in Maryland, in Montgomery County, we experienced a telephone denial of service attack in 2019. It was something that was actually happening to a number of jurisdictions throughout the country, coming from overseas. And we were able to take steps to mitigate it. And technology does tend to catch up, but in some cases it's reactive, not proactive, because bad actors come up with new mechanisms all the time, and then we have to react to those.
Mr. Ferretti.
Yes.
Your time has expired, so I'll give you a couple of moments just to briefly conclude. And
yes. Okay. Thank you. So really, the last thing I'll say is the 911 center is the initial point of entry for public safety response. providing knowingly false information to that has very could have very dire consequences. So that's to include, as Senator Kagan mentioned, leading to serious bodily injury. So I'd urge the commission, or I'm sorry, the committee for a favorable report for this bill.
Thank you very much. All right. Next, we'll move on to Mr. Chiramonte. Close, maybe.
That is actually correct. Good afternoon. My name is John Chiramonte. I'm president of Consulting Services for Mission Critical Partners. We're a professional services firm that assists communities with improving emergency response outcomes. We provide consultative services to clients with public safety and life safety missions, including public safety answering points, PSAPs, and emergency communication centers across the state of Maryland, as well as throughout the nation. My career in 911 began as a 911 telecommunicator and volunteer first responder in Western New York State more than 35 years ago. And over the years, I've served as a 911 and next generation 911 expert to numerous state and local governments, as well as federal agencies. As you're hearing today, swatting is the false reporting of an emergency with the intent of getting a SWAT team response to a location where no emergency exists. The calling party will often report a home invasion, an active shooter, or hostage situation in an attempt to muster the largest possible response. And often that law enforcement response is substantial, with police confronting an unsuspecting victim at gunpoint, only to learn that there is no real emergency. SWATers can use several techniques such as caller ID spoofing, relay technologies, and old-fashioned social engineering. It originally initiated in the gaming community, but swatting has been used to intimidate, retaliate, or unfortunately just for fun. And it's a serious and growing problem for our nation's 911 centers and 911 centers here in Maryland. Several public figures and celebrities have been the victims of swatting, and these incidents place Maryland's residents, at their workers and visitors at risk through unnecessary emergency responses, with the increased potential for serious and, as you heard, sometimes potentially deadly outcomes. Swatting schemes are becoming more and more sophisticated and more common. Just 3 weeks ago, the FBI issued a public service announcement warning that offenders may be misusing smart home devices and smart home cameras to carry out these swatting attacks. Penalty under current Maryland law for making a false report is subject to imprisonment for up to 6 months and a fine of up to $500, as you heard Senator Kagan say. Based on our research, other states' legislation for swatting, Senate Bill 101 would better align Maryland with laws already in effect in some of those other states that have enhanced penalties for persons convicted under their statutes. Besides this legislation, it really is critical for every 911 center to implement additional training for their staff and leveraging emerging technologies like artificial intelligence to improve rapid detection and identification of potential swatting incidents. As someone who has dedicated my professional life to the support of 911 and public safety, I support the proposed legislation with the amendment based on the recommendations of the NG911 Commission to act as a deterrent to strengthen punishment for swatting for all those that would consider carrying out this act. Thank you.
Thank you very much. Next, we will go to Steve. There you go. Souter.
Yes, good afternoon. My name is Steve Souter, and I am the Vice Chair of the Maryland 911 Commission. And I am also proud to say that I represent the public at large at the Maryland 911 Board. And many of you will remember that previously as the Maryland Emergency Number Systems Board recently changed. Before I comment on the subject of this bill, please allow me to take just a second to offer my condolences to each of you on this committee and your colleagues in the Senate, as well as in the House, on the passing of a giant legislator in the form of Mike Miller, Senator Mike Miller. I had the pleasure, like many of you, to work with him over the years. A finer man you will not find, a great legislator, and a person that will be missed forever. So my condolences there. And I would also like to comment on the new member of your panel, somebody that, like Bill Ferretti mentioned, we on the commission have had the opportunity to work with for the last several years, and that is new Senator Michael Jackson. Senator Jackson, thank you very much. We're pleased for you and we're proud of you as well. To the topic of this bill, swatting is simply somebody that has the tools, the electronic tools, to get into and mess up the 911 system, and to, in so doing, dispatch or report events that are false in nature, but you don't know, to locations that are unwittingly the suspect or the subject of that call, many times causing mayhem and chaos, injury, and occasionally death, while the swatter is sitting in the basement with a laptop computer and simply clicking on a mouse and listening to a police scanner radio at the mayhem that she or he has created. Not a good scene. We certainly have penalties associated with that type of activity now, but the penalties are minuscule compared to the magnitude and the impact of the event. So this bill is simply a bill as an attempt to dissuade the swatter before it happens, by letting them know, and they have networks, they know who's doing what, that Maryland is kind of a no-go zone. Stay away from Maryland. The swatter can be in any state in the nation. They can be any country in the nation. They can be in Missouri, or Mississippi, or Montana, or any other men that you want to mention, or any other state you want to mention. So our purpose here is simply to elevate the consequence of that type of activity as a means of dissuading that activity, and by dissuading it, save valuable law enforcement and public safety resources, as well as save the citizen, the unwitting citizen that may be the target of the swatting, so they don't have to go through the experience of that. And with that, I thank you very much for your attention, and myself, as well as my fellow committee members, will be happy to answer any questions that you may have. Thank you.
Fantastic. Thank you all. Thank you, Senator Kagan, Senator Jackson, and thank you to the panelists for your service to our state. Looking around, I do not, maybe something in the chat thread. No, there we go. No questions from the committee. And so with that, that will conclude the hearing for Senate Bill 101 and our hearings for the day. Before everyone breaks off, just really quickly, an announcement for tomorrow. We have hearings. We'll start at 11 o'clock tomorrow, and it'll be followed by a voting session. So we'll be in Annapolis tomorrow for voting and for hearings. So thank you, Senator Kagan. See you later. 11 o'clock, followed by voting session. See you all tomorrow. Have a good one.